guys, it's Kathy. I hope you're doing well. Thank you to everybody who showed up last night to my live stream. Did I see Lucy was here? Hi, Lucy. Okay, so I have a 6-hour trial that I cut down to 2 hours just for this morning's live stream. Okay, and what I cut out was they brought multiple officers. They all said basically the same thing. And then I cut out, they went off on this tangent about a mistrial that meant nothing. It was really bad and boring and painful. Cut that out. So all we really have is one officer, a bartender, opening statements, closing statements, and then the jury verdict. So that's what we're going to be watching today. It's in Georgia. There are accents. I don't think they're bad, but I don't really remember. And then I have to go take care of something real quick. I just have to. So I will be right back. But I'm going to start this and be right back.
On talking for forever. I mean,
I do not have an opening statement from the prosecutor. I just don't. But we have Bodycam. So I would rather have Bodycam.
evaluate her credibility. You evaluate, and I agree with the state. You know, everything's not about chemical testing. We all have human experience, right?
And I sped it up so that it fits in 2 hours and 6 minutes. If it's way too fast for us, let me know. I can slow it back down. Yes, I got to kick you out of my shower because no.
We know if someone's falling on the floor drunk. We don't need a scientific test to tell us that. But the state will say, well, look at all these other clues and indicators and factors, and I encourage you to do the same thing. I mean, she's talking clear as day, answering questions. You know, she's got a unique personality. She's quirky. I like her. She's quirky. I mean, I'm quirky too. I'll probably be quirky at some point during this trial, but it doesn't mean I'm drunk right now, and the evidence won't show that she was drunk and driving under the influence. But she's answering questions perfectly fine. The evidence will show that she seems baffled, like, why is this happening? And she asked that repeatedly throughout this, 45-minute, hour-long interaction, really an hour plus, I guess, overall. But you get to decide for yourselves, what does the evidence show? And it'll be clear she's fine. And the trooper comes and you get to evaluate that interaction as well for what that's worth, and ultimately makes the decision to arrest Dawn for driving under the influence. And the evidence will be lacking. It's wholly insufficient, with all due respect to everybody on the other side. I mean, it's not only is it lacking and not going to prove driving under the influence beyond a reasonable doubt, but really the evidence clearly indicates that she's not under the influence of alcohol to the extent that she's incapable of driving. That's what less safe is, incapable of driving safely. Not 20 other words out of the dictionary, that's the legal definition. And the evidence will show that not only will it not show beyond a reasonable doubt that she's guilty of DUI, but it'll show she's sober. If you use common sense and reason and honestly seek the truth and evaluate it for yourself, look at the videos, listen to the audio. The state's got it all, they'll play it for you. You honestly seek the truth and determine what you believe. Does she appear to be incapable of driving safely? No. And the trooper says, well, my lights were on and that's, she hit me, and he calls it over the radio. Yeah, she backed into me with my lights on. Well, actually, no. He then goes, a couple minutes in, he realizes his lights aren't on. You see in the camera, he goes, opens his door and turns the lights on. So he didn't have his blue lights on at all. And, the trooper has in his report, lights were on when she backed into him. The supervisor from Hall County wrote a report, same exact thing. I mean, no one's corrected any reports, and then we'll see how that evidence plays out and what explanations you get for these inconsistencies, but I think you all will know the real explanation. I mean, whether or not you get that answer from the stand, I doubt it, but you can use your experience and your encounters in your life to answer those questions for yourself. So I appreciate your patience your attentiveness. I do expect will be done today. And at the conclusion of this, I think you'll be unsettled, dissatisfied with the presentation. And the judge will tell you at the end of the trial that feeling of dissatisfaction. I'm not settled with this. I don't feel at ease with this. That feeling is the definition of a reasonable doubt. If you can give a reason for your doubt, that's a reasonable doubt. Any reason you can list. But also this feeling of being unsettled and dissatisfied. And you will feel that way at the end of the trial. And when you feel that way at the conclusion of the trial, I'll ask you to find Dawn not guilty. Thank you.
All right, thank you. All right, we're now ready to begin the evidence. Does either side wish to invoke the rule of sequestration?
Yes, Your Honor.
All right, so with the exception of the arresting officer or the main officer who's been excluded, anyone who's not the first witness in the case and expects to be a witness in the case, if you would step out into the hallway.
Ms. Cherry, would you raise your right hand for me? Do you swear affirm the testimony you give today be the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, you can put your hand down and have a seat if you'd like. We've got a court reporter taking everything down. She's not here in the courtroom with us. If you just speak directly into that microphone as you're talking, that way
Okay.
she
Yes,
can
sir.
take down what you're saying. All right, thank you. Would you please tell the jury and state loud enough for the court reporter what your full name is, please?
Jennifer Marie Cherry.
All right. What do you do for work?
I work at the Twisted Oar. I bartend and manage.
You're still working the Twisted Oar?
Yes, sir.
All right, how long you been working there?
10 years.
10 years. Can you tell the jury what you do at the Twisted Oar?
I bartend and manage the restaurant.
Were you working at the Twisted Oar on March 19th of 2024?
Yes.
All right. Do you recall what position you might have been working that day?
I was bartending and managing.
All right. Do you recall an incident where law enforcement had to be called out?
Yes.
All right. What do you recall about that incident?
Like how it started.
I don't need to say what anybody said or anything else like that, but
Well,
why was law enforcement called?
There was a lady and a gentleman. The gentleman was intoxicated. I wanted to get him in an Uber, and the lady took his keys and wallet, would not give them back. He wanted to get in the Uber, and the only thing I could think to do was call the police to get his property back.
All right. And I know this has been a few years ago at this point, do you see that woman in the courtroom today?
Yes, sir.
Can you identify what she's wearing by an article of clothing and maybe tell me where she is?
White shirt, cool socks.
All right. White shirt.
Cool socks.
If the record reflects that Ms. Cherry's identified the defendant.
Yeah, so yes, cool socks.
Socks.
So reflect.
Was the defendant she identified, was she drinking there at the bar that day?
Yes, sir.
Do you recall what she had to drink?
I do not recall what she had to drink. No, sir. I know she was drinking, but 2 years ago, I weighed on hundreds of people.
Yes,
I
ma'am.
do not recall.
I understand. Do you recall seeing the defendant discard or dump out any of her drinks?
No.
All right. So to your recollection, did she consume everything you had served to her?
Yes.
All right. Do you recall telling deputies that woman arrived at the bar at about 1:15?
I'll allow it. You can answer the question.
I don't remember.
Yeah. All right. And do you recall telling the deputies that you served that woman 2 double Jägermeisters?
Leading. She just said, I don't recall what she had. He's leading her.
The first question was to the time. The second was to what she had to drink.
Okay, well, you can ask a yes or no question. Don't ask a isn't it true question, but I'm going to overrule that objection. So if you know the answer to the question, Ms. Cherry, you can answer it.
Sorry.
You want to repeat the question?
Yes, ma'am. Do you recall telling the deputy that you had served the defendant 2 double Jägermeisters?
No.
All right. I have no further questions, Your Honor.
Just a brief cross, if I may.
Yeah.
May I remain seated, Your Honor?
Yes, you may.
Ms. Cherry, is it fair to say you don't particularly recall that day other than having to call about Ms. McCarroll having this gentleman's keys?
Yes.
And your primary concern being he was intoxicated, and do you recall not wanting him, you yourself not wanting him to drive and calling the Uber?
Yes. Yeah, I got the Uber through his app on his phone for him.
I mean, is it fair to say you don't recall specifically today, as you sit here, you don't recall, or even probably on that particular day, exactly who consumed what drink, like if it was ordered or shared or something along those lines?
They were drinking 2 different things.
Okay. Well, okay. I don't have any other questions.
Any redirect? All right, Ms. Cherry, any reason why she cannot be excused? You want her on call? How do you want to handle this?
She may be excused, Your Honor.
Yes, Your Honor.
All right, Ms. Cherry, you may be excused. Do you swear affirm the testimony you shall give in the matter now pending before this court shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
All right, thank you, Trooper. You can have a seat, make yourself as comfortable as you can be up there, and speak into the microphone if you would. All right, Mr. Elliott, you may proceed.
Trooper Talton, would you tell the jury your full name?
Certainly. Michael Talton, from Georgia State Patrol, retired.
That day, were you wearing your uniform,
Yes.
including your badge?
Yes,
Were you operating a marked patrol vehicle?
I was.
Do you recall responding to an accident involving a Hall County Sheriff's Office vehicle?
I did, yes.
All right. When you responded to that accident, did you identify the involved parties?
I did, yes.
All right. Was Miss Dawn McCarroll one of those parties?
Yes, she was the driver of a black Jeep involved.
All right. Are you familiar with her enough to tell me if she's in the courtroom or not?
Yes, the lady at the defense table in the white blouse.
All right, thank you. How did you become aware that you were needed on scene for this?
I received a call from our dispatch to go to Holiday Marina on State Route 347, Holiday Road, near Honest Parkway, whichever it goes by now. And so I don't remember where I was, but I headed that way and got there in about 15 minutes.
Was that here in Hall County?
It is, yes.
When you arrived, can you describe what you saw?
So when I arrived on the scene, I saw a deputy's vehicle stopped at an angle behind a black Jeep, and it looked like it was in a parking space, but maybe it had been trying to exit. Of course, when I got out, I observed.
Do you mean by roadside drug testing just like the test that the police carry on them? So they can test that right there at the scene? Yes, we have that. Or do you mean like a DUI checkpoint where they pull all the cars over and they check everybody? Yes, we have that.
Observed that the rear of the Jeep was touching the front bumper of the patrol vehicle.
Is it common for you to, when you're working for Georgia State Patrol, is it common for you to investigate accidents?
Every day.
You've received training in traffic investigation?
Yes.
All right. Have you also received training in drunk or impaired driver detection?
Yes.
And how to investigate drivers suspected?
I have never actually gone through a DUI checkpoint. We have them around, I mean, it's mostly like on holidays where we'll have DUI checkpoints on the roads, but I've never actually driven through one or been in a car where we've been through one. So now they can't do that. Like, they do have DUI checkpoints, but they can't just randomly pull you over here and do a breath test. They have to have probable cause to just pull you over. But they do have checkpoints, which is no probable cause.
Of being under the influence of alcohol?
Yes.
What did that training consist of?
The training consists of a 3-day course, 24 hours. You receive instruction from qualified instructors on detection of persons who might be intoxicated, how to do standardized field sobriety testing, other mannerisms to look for, body movements, talking, other mannerisms, listening to what they say, different kind of questions to ask. During the training, you're also allowed to observe and interact with persons who have consumed alcohol, of course, in a controlled environment. Different levels of intoxication from hardly intoxicated to highly intoxicated.
And that's in a classroom setting?
Yes.
Are those people given specific amounts of alcohol so that their blood alcohol concentrations are known?
Right, but we're not allowed to know that ahead of time. We just know they've been drinking, and we're allowed to observe them and do evaluations on them to try to determine how intoxicated they might be.
And those evaluations, are those called standardized field sobriety exercises?
Yes, that's correct.
All right. But did you pass that training?
Yes, on 2 different occasions.
When did you pass that training?
First time was in July of 2003 while I was still at the Commerce Police Department. And then during the State Patrol Trooper School, it is required part of the curriculum, so I completed that again in the fall of 2005.
Across your, was it 31 years of experience?
Almost 30.
Almost 30. Across those nearly 30 years of experience, have you had a lot of opportunity to engage with suspected impaired drivers and impaired drivers?
Yes.
You know about how many times?
Hundreds.
And throughout your career in law enforcement, have you dealt with other people who were intoxicated with alcohol who weren't driving cars?
Yes, while especially at the City of Commerce Police Department, you respond to disputes, disturbances, family matters, and not uncommon to find someone at a house who's not driving, but they're intoxicated.
When you arrived on the scene, did you speak with the defendant, Ms. McCarroll?
I did, yes.
All right. Do you notice any odors coming from her?
I noticed the odor of an alcoholic beverage on her breath.
Did you notice anything about the defendant's eyes?
I'm sorry.
Did you notice anything about the defendant's eyes?
I noticed they were slightly bloodshot, not anything fiery red, something you had to be fairly close to see, but I did notice it.
And then, if we had a photograph of that, and we have Exhibit 2 anywhere? Could I step in the jury?
yeah, go get it. Defendant's Exhibit 2.
Defendant's 2, yes, Judge. And I've just handed the witness defendant's Exhibit number 2. Would you take a moment and familiarize yourself with that image, Trooper Talton?
So it appears it's a still shot of Ms. McCarroll from one of the deputies' body cams.
All right. Direct your attention to her eyes on there. Do you see in that photograph that that Ms. McCarroll's eyes are bloodshot and watery?
It's hard to tell in this photograph. It's not as close.
Yet it's my eye that's swollen. Brad.
It's from a lower angle, and her eyes are actually in a shaded portion on her face, not in the sunlight.
So do you think the angle of the photograph and the shading might impact an ability to see whether her eyes are bloodshot from a still photograph of a camera?
Yes, I mean, from my experience, things, small, minute things of that nature, might not necessarily be detectable on the camera, but certainly visible to someone's naked eye.
Thank you. You can set the exhibit down.
We should go back to that for a second, V. I wonder if they pay people to get drunk so that police officers can train on how to spot drunk people. Because I would like that job. How much does it pay? And if it doesn't pay and they just take volunteers, I'm good with that too. I'm good. I'll volunteer for the greater cause. Monica, thank you for the cheers. Thank you so much.
We're interacting with the defendant, Ms. McCarroll. Did you notice anything about her demeanor?
Yes,
Would you describe her demeanor for me?
certainly. He was talkative, somewhat argumentative, complaining, constantly asking the same questions over and over. At one point crying for a moment, then not crying. She would at times, not often, but a few times, did use profanity. And I guess confused about what happened, maybe some of the actions that were going on, even though it had been explained to her time and time again.
Would you say she also moved, or her demeanor moved back and forth between being normal and compliant and into aggressive?
Yes, it would change. She'd be argumentative and then compliant and then change again.
If the defendant had taken somebody's keys without permission, would that indicate to you impaired judgment in any way?
Objection, speculation.
I do think that question's kind of speculative. I mean, you can ask if it mattered at all in his analysis, but
Did the fact that the defendant had taken keys from another individual without permission factor into your investigation in any way?
It showed somewhat, perhaps, poor judgment.
Did you at one point ask the defendant to provide you her?
I have had 2 beers in the last 3 or 4 months, which breaks my heart. My heart is broken.
Driver's license?
Yes.
All right. And did the defendant go and look for her driver's license?
I'm not sure. She gave it to me, or if one of the deputies already had it, and he provided it.
All right. Your uniform, you don't have a body camera, do you?
No, not like the deputies, no.
All right. Do you have any sort of recording equipment that you wear on your body?
Yes, the car is equipped with a dash cam, and on my body I keep a microphone which also records audio while you're outside the vehicle.
All right. On the day we're talking about, were you wearing your microphone?
Yes,
Were you operating a car that had a camera in it?
I was, yes.
All right. Was that equipment functioning?
It was.
All right. Have you had an opportunity to review the audio-visual recordings from your equipment that day?
Yes,
All right. Did you review those recently?
within the last week.
Last week, all right. You saw some played yesterday during another hearing we had, is that
Yes.
also correct? All right. That video or that recording that you observed, is that a fair and accurate depiction of what happened? You don't see any alterations or deletions or changes to it?
No, it's a fair and accurate copy of what happened.
All right. Your Honor, I'd like to mark State's Exhibit 1E. It's going to be a video titled Michael Talton _ 2024 0319 1557.
What I should do, what I should make it a policy, is I get a drink, I get a shot, I get a beer, I get something every time I find a clip. So that would train me into finding multiple small clips instead of one nice long trial like this.
_GSP 0279B-1.
Okay, and so you've marked it, and you are tendering it?
Tender it and request to publish.
Okay, well, hang on. You've tendered it. Any objection?
None other than, I don't recall any particular hearsay issues, Judge, but none other than just any possible hearsay.
Okay, then it's admitted, and then you may publish throughout your direct.
All right. And then we'll start the videos.
Technology.
I got Bodycam because Monica loves Bodycam. But you can't really see it because it's on that little TV. Maybe I'll
Can you
try to
wait?
make it bigger.
Yeah, I can black it out until you're ready.
1 second. B1.
Okay.
Getting it.
Okay. And we're going to start from the very beginning. Okay.
And we're starting from the very beginning.
Okay. You can proceed.
Might help if I have audio.
Okay. 1E.
I'm going to stop.
How you doing, sir?
Very good, sir.
You need his license.
Yeah.
Probably looking for it, right?
No, because
Y'all in the car? Out of the car.
Just when the car stepped out, and so when we pulled in, the reverse lights came on. I pulled behind her. She stopped. We got out, and she started back. I started yelling at her. And
When you parked for that, was she still pulling in the park? Or had she
she was already stopped,
Okay.
parked, and then when we come in, the reverse lights come on, and she took somebody's keys. So we pulled in the stop. She stopped. We both got out.
Y'all are you parking out? Yes.
Like I was telling him, I don't know how fast this is going to turn on, but I'm pretty sure it's probably in there.
Okay. What'd you say when y'all got out?
She was backing up, and then she stopped, and then he ran into her.
She admitted to me she had 2 Jaeger bombs up there.
2 doubles.
Well, she told me 2 Jaeger bombs. The bartender told Bailey she had 2 doubles of Jaeger. Now, is that camera pointing here? Yeah, they said that there's a camera point over here for the guard. Like, just to somebody had gone.
So she actually hit the police cruiser.
Do you want me to turn this on?
Right. No, just like yeah, ID for me. Like just I'm as a witness.
Oh,
Yeah.
like telling what?
this guy here?
Yeah. No. Right here.
Yes, sir. Take your license.
Hey, Mr. McCarroll, how are you? Well, you by yourself, Joe Keith? Looking for the 4-wheeler, huh?
Right here, sir.
Okay. You wasn't hurt anywhere, were you?
Let me borrow just a second. I'm going to take a picture of it, and then I'll look at that.
Not hurt anywhere, are you?
No.
All right, then. Tell me what happened.
Pulled in. Started backing out, and this.
Had you been in the bathroom yet?
No, I'm trying to, and they won't let me. I've asked them a few times.
All right. So you pulled in here to park. You go to the bathroom?
Yeah.
Where's the bathroom?
My friend's house. That's why he came to come get me.
Okay, he was going to get you and take you to his house to use the bathroom?
Yeah.
Okay. Where are you coming from?
But where?
Door? Okay. Been down there for lunch?
Yeah, I got my friends some potato skins and a lot of water.
Okay.
So I was taking care of a friend of mine.
All right.
So
You was backing out, you didn't see a deputy behind you?
but I tell the truth, am I going to get in trouble? No, obviously.
Well, I don't know. How was you backing up? Was you looking out the mirrors or were you looking out the back
I
window?
reverse and I saw blue lights. I stopped and then someone hit my Jeep, to be honest with you.
Okay. What she just said there to the officer was, I saw blue lights and he hit me. So that's what she just told the officer. She saw blue lights and then the officer hit her.
He's so mad at me. Tell me the difference, and I understand his authority, but that's what happened.
Okay. All right. How much you had to drink over at the Or?
2 Jaegers and 3 waters.
2 Jaegers?
I'm overly honest. That's my therapist.
I don't know you.
2 Jaegers, 3 waters. That's what she said she had to drink.
I know, but I am.
Okay.
But I've been coaching I don't want to tell everything about my friend. I feel like I'm
Who's your friend?
the one who said I had the keys, who called the cops.
Oh, okay. All right. So kind of
No,
a
I took the
dispute
keys.
going on.
He couldn't drive. I gave his wallet, and everybody else had the keys.
Okay. All right.
I take off my jacket. This is too much for me.
You can take your jacket off if you want to.
Thank you.
Still live in Woodstock? Cherokee?
No, I actually live at Linear Avenue.
Live where?
Linear Avenue. What is going on right now?
Well, we've had an accident here. That's why they've called me out here. I don't know anything about the dispute or the keys missing. That's between you and these gentlemen. All right. Here because I got two.
Well, because
What's your new address?
1047 Linear Avenue. May I light a cigarette?
No, not right now. Linear Avenue. All right.
Can I go to the bathroom at this point, or that's right?
1047 Linear Avenue. Where's that? Gainesville. 3050.
0501.
Okay.
I should just point out right there, she said, can I light a cigarette? He said no. That becomes a big deal.
Telephone number for you.
404 310 8877.
8877. Who's your insurance? State Farm. Okay.
Yeah, Lisa's, she's a good friend of mine.
Good friend of yours? Okay. All right.
Why is that? Okay, I don't care. I just want to know what's going on.
Okay. Well, I told you, I'm just here because the vehicles made contact. What's going on before that? I don't know about the keys missing and your friend and all, okay? These gentlemen here to talk over that with you. So you had the 2 Jaeger bombs and 3 waters?
Yes.
Okay, all right.
Time to be about 5 minutes. 5 minutes, 52 seconds.
Then we're going to resume at 6 minutes and 8 seconds.
Six, 7, 8. Okay, 6:12. Okay, 6 minutes, 12 seconds.
No, I'm nervous because nothing. If I say anything, I'm in trouble. No, can you fucking take me?
All right.
Okay, this is me.
Bren, you can squirt little flavors in your water, and then you can drink more water. It's important.
Just a moment. Where do you have them at?
I said this is the 3rd time. This is Georgia. Georgia.
What?
Maybe a fake towel.
Oh my God, thank you.
You're welcome.
Okay.
I know how a runny nose can be. It can be aggravating sometimes.
Well, because now, what the hell is going on right now?
I told y'all, I'm here about this. All right, what happened about the missing keys and you dispute with the...
This is what I'm talking about, guys. This is exactly what I'm talking about. When I first started this clip, I said we're in Georgia. The accents are there. Then Donald said, what state are we in? And I said, this is Georgia. Then he said, this is the 3rd time I'm asking what state are we in. Now, I made one comment about Bren. 38 minutes later, you all told on me when Bren came in. So I give important information about what we're about to see, and ain't nobody hear me at all. Nope. But you remember that.
Friend or whatever, I don't know.
It's not.
Okay, but I don't know. All right. These gentlemen over here talk about that with you.
That's fine. This is crazy.
Okay.
I literally.
All right.
I wish I had this picture right now of all you guys. All right.
Wait for me right here just a second, okay? Don't run off. Not yet. Wait right here. Wait. Y'all need to talk to her about the dispute.
We've already finished that part up.
Okay, all right. I don't want to finish on
Got it.
to the past 2 hours. All right.
So 2, double, yeah. Go back over.
She go with the order.
Yeah. This you know, I thought to stop off.
Okay.
That's what that's probably about 200. Oh, that's all.
All right, Mr. Carroll.
Well, I'm gonna imagine what they,
All right. They said they're finished with you about the dispute and the keys. Now, apparently they got all that straightened out, okay?
yeah, I know.
All right.
Because-
Okay. All right. All right. All right.
Do you mind if I?
Mind what? Don't
I'm
touch
touching
me.
it.
No, don't touch me.
I know.
That's all right.
How many licenses do you have right now?
We'll have yours and the 2 gentlemen that were in the car here.
Which one?
2 gentlemen that were in the car. So we had a wreck. I got to put their names and all down. So,
Freaking embarrassing.
so you had the 2 Jaeger bombs with lunch.
No, 2.
2, that's what I said. And 3 waters.
It's on the tab. He had
Okay.
3 waters. And
All
I
right.
also fed John 5 waters before we left.
Okay.
And I also took his keys from you.
Confusion.
Why was that?
And you know, we're gonna let him drive.
You had too much to drink, you think? Well, I mean,
Yes.
that's a good thing if you thought he was.
If you want to talk to the people at the door,
Good.
I can you're up there. I even ordered potato things. They even called 911. I asked him to stop. I took his keys. I did give his wallet and phone back so he could take an Uber back.
Good.
And that's when I left and I stopped here. My friend's house that was right there on Dock Point.
Okay. That's not a house, that's a boat.
It is a boathouse. It's amazing.
Okay.
House.
All right.
But that's where I was at.
Okay.
And next thing I know, I think, I don't know if he, I don't know. Next thing I know, there's Jared.
Sure, fine. Okay. But apparently I got that straightened out about the keys.
And do I think I hit him? No. Do I think he hit me
Okay.
because he saw me there and thought maybe whatever? I don't know.
All right.
Either way.
All right. We'll put all that down then. It's not uncommon to have 2 different sides to the story.
That's fine. There's always a third side.
Well, I don't know about the third side. We only have 2 cars.
Either way, we can tell he hit me. But what I'm saying is that I have a steel bumper. And, you know what, whatever happens today, as long as I'm not arrested, John's safe, and I don't care. So,
Okay.
As long as I'm not
I'm good
arrested,
enough.
she says.
How old are you?
really, 50 months.
Born in 72. Okay. All right, Mr. Carroll.
No.
Listen to me, all right? All right. Right now, I'm placing you under arrest for driving under the influence.
Wait, why?
Well, because you've had too much to drink.
I've had 2 Jaegers.
I understand that.
That's it.
Right.
No.
Right.
That's not enough.
And you backed up and hit someone.
I did not. He hit me.
That's your opinion.
Please tell me you're not under arrest.
What did I just tell you?
I'm not.
Yes, you're under arrest for driving under the influence.
I didn't even drive.
I'm sorry?
I didn't drive. He hit me.
That's your side. You're welcome to come tell that in court.
May I say something?
No, not right now. Finish what I got to do here and we'll get out of here, okay?
But you're going to put me under arrest.
I just told you that
You're going to
twice.
take me to jail?
Yes, ma'am.
I wasn't even driving. Can we
I've
look
heard
at the
you-
body cam?
I'm sorry?
Can we look at the body cam?
Those guys were standing outside the car when you hit them.
Can we talk to them?
You can ask them that in a few minutes, all right? Let me finish what I've got to do right here, okay?
Okay.
All right, listen to me. Got something I got to read to you. Just listen close, all right? The state of Georgia has conditioned your privilege to drive on the highways of this state upon your submission to the state of chemical test of your blood, breath, urine, or other wrong substances from the first determination if you run them from alcohol or drugs. If you refuse this testing, the Georgia driver's license privilege to drive on the highways of this state may be suspended for a minimum period of 1 year. Your refusal to submit to blood or urine testing may be offered in evidence against you at trial. If you submit the testing and results indicate an alcohol concentration of 0.08 grams or more, the Georgia driver's license or privilege to drive on the highways of the state may be suspended for a minimum period of 1 year. After first submitting to request a state test, you're entitled to additional chemical tests of your blood, breath, urine, or other bodily substances at your own expense and qualified personnel of your own choosing. Will you submit to the state of mental chemical test of your blood?
No, I have a pair of needles.
Okay. Well, let me finish, okay. Will you submit to the state? Let me finish. Will you submit?
Stopping at 13 minutes, 8 seconds. Resuming at 14:48.
Like what?
Am I really being arrested?
About how many times have I told you that?
But for what?
Driving under the influence.
I wasn't driving.
That's your opinion. You're welcome to tell that in court.
Oh, wait. Wait a minute. I was not driving. May I go ask the question?
No, not right now.
Why? I
Go.
was not driving.
I think you've told them that. They've heard you.
It shows clear I was not driving.
Do you have anything in your pockets?
No. Am I really being arrested?
How many more times you gonna ask me?
I don't know. I'm just.
How many more times do I need to tell you?
Okay.
All right.
May I make a phone call real quick?
Not yet, no. You have anything up here?
No.
She absolutely was driving, and she absolutely did run into him. He didn't hit her.
What's all that? What about this shirt under your sweater there?
It's just a shirt.
Yeah, but it's probably got pockets on it.
There's nothing in here.
Okay.
I'm being arrested?
Wait for me right here, okay?
May I go get my phone?
No, wait for me right out here. Can somebody take her to a bathroom? I don't got me between here to jail. She might lose it. If there's a origin or something, I don't mind she goes to the bathroom. I'll get her paperwork up there.
Okay, what if I did it?
Carol.
What if I admit I hit your car? Are you really doing this? I didn't hit your car. What if I...
Carol, come here. Listen to me.
I can't really...
Look, I'm trying to arrange for you to go use the bathroom, okay? You bear with me, okay?
But I'm still getting arrested for something I haven't done. Oh, man, I did not. I have to admit I hit the car.
You don't have to admit anything like
I
that.
did not.
All right.
Something... All right, what do I do then? This is... What do I do?
Suppose let me read this to you right quick, and then Deputy Day is going to work something out for you, okay?
Please.
Listen to me, all right? Listen, Mr. Carroll. All right, you have the right to remain silent. Anything you say can will be used
You're
against
really
you in a court of
arrested?
law.
I didn't do anything. I'm literally
You have the right to talk to your lawyer and have him present with you while you're being questioned. If you cannot afford to hire a lawyer, one will be appointed to represent you for any questions if you wish.
parked here.
You can decide at any time to exercise these rights and not answer any questions or make any
I was
statements.
parked here.
You understand each of these rights as I explain them to you.
Sorry, freaking Chief. Are you kidding me right now?
Having these rights in mind, you would speak to me now. Since you weren't listening and paying attention, just arguing with me, we're just going to assume you said you don't want to speak to me, okay?
I do want to speak to you.
Well, let me read this again, and you tell me a direct answer, okay, without cussing at me and complaining about them, okay?
Yes.
This is you and me, all right?
I'm kind of underwhelmed about
All right. If you'll work with me here, I'm trying to get you to a bathroom, okay? You want to ride all the way to Gainesville holding it? Listen to me. You have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to talk to a lawyer and have him present with you while you're being questioned. If you cannot afford to hire a lawyer, one will be appointed to represent you before any questioning if you wish. You can decide at any time to exercise these rights and not answer any questions or make any statements. You understand each of these rights as I explained them to you. Having these rights in mind, you would speak to us now. Yeah? I'm sorry?
Yes.
Yes.
Now, what I would like to know is what I'm being arrested for.
Driving under the influence. Same
I
thing
was
I've
not
told
driving,
you.
though.
Ms. McCarroll. That's your side of the story. I've got the other side over here, and that's what I'm going with, okay?
So, how do you prove that, though?
Well, you get to come to court and tell your side.
But I have to go to, am I going to be booked and be stuck in jail and have to get bonded out for 12 hours?
That's usually the way it works, yeah. What's the plan about the bathroom?
If you're okay with me and him, you want to take her up there to the bathroom real quick?
You okay with that, Mr. McCarroll?
I'm actually going to go to jail for 12 hours.
I don't know if you're going to be in there 12 hours. That's between you, the jail, and making bond.
Because, no, but don't get mad. Don't get mad.
I don't know if that's normal. There's 4 officers there for her. 4.
Don't get mad when I say it.
Don't get mad.
Because you're telling me I backed into your car. So I'm getting brought to jail. No, I'm being serious. Is that right?
Because you're driving. Do you want to go to the bathroom or not? Let these gentlemen take it and come back, all right?
2022. And do you have any questions for the trooper in between the video playing about what's happening or anything?
I could. Trooper Dalton, did the defendant tell you how much he'd had to drink?
We see often when people are arrested for DUI, they have to use the bathroom. And they're like, I gotta go to the bathroom, I gotta go to the bathroom, I gotta go to the bathroom. Now, in her defense this time, she did just say she had 2 Jaegers and 3 waters, and she has been standing there at the roadside for over an hour now. So,
She stated, I think, 2 Jaegers or Jaeger bombs and 3 waters.
Did the defendant tell you whether she saw blue lights prior to getting into that crash with the deputies?
Yes, she stated she saw them
The defendant tell you she didn't drive?
several times.
So she denied driving several times?
Yes.
All right. And did she ever say she wasn't under the influence?
Yes.
She said she wasn't under the influence?
Yes.
All right. The defendant, what reason did the defendant give you for not wanting to submit to a blood test?
She stated she had a fear of needles.
Anything strike you as odd about that?
Yes, I had noticed earlier that she had at least on her hand, I saw a small tattoo.
Where are you going to resume playing the video, Ms. Williamson?
2852.
And
Do you want to play it now? Or?
if you give me just a couple more questions, and then we'll get it going. Did you ask the defendant at some point whether she would participate in field sobriety exercises?
I did.
Did you wind up performing field sobriety exercises?
Yes, I wanted to and ask her if she would allow me to.
But she did not do field sobriety exercises?
No, she
is that
declined.
correct? All right.
Judge, I'm sorry, but I've got,
We have a matter we need to take up outside your presence. Y'all take a quick recess. What you doing, Mr. Elliott?
That was the last of the questions on that one, Your Honor.
Yeah, you might have just gone too far. Ashley, do you have the ability to read that back to me? I thought we agreed we weren't going to talk about her refusal to submit to field sobriety tests in compliance with Georgia law.
that was absolutely the order of the court. And that was absolutely a direct question, soliciting that answer, and absolutely an answer, answering the question asked. And I respectfully move for a mistrial. There's no other remedy.
I want to hear the answer. Ashley, do you have the ability to read back the question and answer?
Which one, Your Honor?
Where Mr. Elliott started asking about fields.
Do you have a case? That's where you're going to. Did you see this? Did the defendant at some point whether she would request? You also kept out of the video. What matter I need to take outside your presence? All right, give me 1 second. This is my first time doing this.
You can actually play it back, can't you, Ashley?
Yes, ma'am. Let me get my mother. She got back just a few minutes ago, so let me get her to do it.
Well, hang on. I want to hear the question and answer. But I'm going to let you respond, Mr. Elliott. I just need to hear the exact question and the answers. I think there were at least 2 questions and 2 responses, but I wasn't taking verbatim notes.
Okay.
Hang on. Let me go to this. That might be required.
Okay, Judge, I'm in here. What is it y'all need?
It's probably the last 2 questions and last 2 responses from this last witness, and it's regarding field sobriety.
Awesome. Okay. What is this? Is this question and answer, or is this colloquy? You got witness and Mr. Elliott, everybody talking.
I still need question and answer. It's the question and answer.
To hear it. Okay, hang on a minute.
I'm a little surprised because she says that she had 2 Jaegers, which wouldn't put her over a limit. She said she had that waters, which would definitely help. And if you don't take them, don't you lose your license for a year automatically? So I'm a little surprised she didn't take the test. Hi, Rose.
I am right here. I can say a thing when I walk in. You gotta get some things. Yeah. No, I need a lice. Oh, yes, ma'am. This is flying out of the thing anywhere. That's me. You're hearing something? Yeah, in this. Okay. Well, now I'm not hearing anything. I've unplugged you. It should be coming through the speaker.
Is there anything I need to do on my end, Sharon? You think? Because of the...
No, I'm trying to get it to play through the speaker instead of through the headset. And
Right.
I'm looking at the audio right now because that's why it's not doing anything. It's wanting to play through the headset, but then it's not wanting to give it to me through the speaker. Okay, wait a minute. Let me just do it a different way. Give that to me. Okay. Did that tell you whether she saw blue lights prior to getting in? She stated she saw them. Did the defendant tell you she didn't drive? Several times. So she denied driving several times? Yes. Did she ever say she wasn't under the influence? Yes. She said she wasn't under the influence? Yes. What reason did the defendant give you for not wanting to submit to the blood test? She stated she had a fear of needles. Anything strike you as odd about that? I noticed earlier I saw a small tattoo.
And then it's probably the very next question, Sharon, right after that.
Okay. There's a pause. Hang tight. Then you ask, are you going to resume playing the video? Ms. Williams says a time marker. Ms. Williams, and then Mr. Elliott says there's a couple more questions. Did you ask the defendant at some point whether she would participate in field sobriety exercises? I did. Did you wind up performing field sobriety exercises? Yes, I went into that and asked her if she would allow me to. But she did not do field sobriety exercises, correct? APOP, yes. Is that all you need?
Yes.
Okay.
What do you need, Mr. Poole?
Sorry, I think if there may be one more question and or answer immediately following, that may be the end, but.
Is that it, Sharon? Or is there another one?
It's still playing and I'm not hearing anything else.
Okay, that may be everything.
So the question was, did you ask the defendant if she would submit to field sobriety exercises? Yes. Did she end up, what was the next question? Is there any way you can say it again, Sharon? Or is it too hard?
Wait just a minute. Let's see. So you want the previous question?
Yes, that's the second for the follow-up.
Okay. Did you ask the defendant at some point whether she would participate in field sobriety exercises? I did. Did you wind up performing field sobriety exercises? Yes, I went into that and asked her if she would allow me to. But she did not do field sobriety exercises. No. And then Mr. Pruitt makes a motion.
Okay. All right. Very good.
Okay.
That's what I needed. Thank you.
You're welcome.
I got a feeling.
All right, Mr. Elliott, you want to respond?
Tonight's going to be a good
Your
day.
Honor, I believe the case law is that the defendant's refusal cannot come in. The trooper made the request. It's something the trooper made. But the fact that fields weren't conducted, I think, is highly evident throughout the rest of this video. I dare say that's kind of an obvious statement on there. There were a couple deletions from the video. So I guess there's a possibility she did fields that wasn't on the video, but I think it's pretty obvious that she didn't do the field sobriety testing. So the trooper asked, and then he said he didn't conduct the fields. Nothing was said about whether the defendant agreed to it, disagreed to it, had any commentary on the field sobriety exercises, gave any reason to not participate in the field sobriety exercises. So,
Mr. Elliott, if you were having any idea that you were going to go near the subject, you should have previewed this with me, because we have now created a situation where Mr. Cole can't cross-examine about this. That's the problem with it. Like when we previewed this issue, and I was like, nobody's going to talk about fields, right? And everybody agreed that the refusal didn't come in. I understand what you're trying to do. The problem is now the jury doesn't know what happened, right? They know he asked and they know she didn't end up doing them. Now I get that that's different than giving the jury the inference, right? But how is he supposed to cross-examine about that at all without getting into it? Now he can't.
I'd argue that the defendant can get into that if she would like. Now I can't get into it for sure. I cannot bring in her refusal. So I can't bring in the fact she refused to participate in the fields. I agree with that. Doesn't mean that Mr. Poole can't on her behalf bring that evidence in. It's not wholly inadmissible. It's the defendant's to waive. If Mr. Poole feels as part of his case strategically that he should cross-examine Deputy Talton as to why there weren't fields, that's entirely on Mr. Poole. But I had no further questions after that.
Well, I wouldn't have let him do that though. That's the point. I wouldn't have let him badger Talton about why he didn't do fields when she refused. But now you have stepped all in this when I thought the pretrial ruling was pretty clear that we weren't going to talk about it.
It was the refusal on the pretrial ruling, Your Honor, and I ensured that there was no video of it happen.
Yeah,
Not
but
even
you
the
asked
request.
him about it.
Well, I did ask him if he requested it. I think that him conducting a thorough field sobriety exercise, set of field sobriety exercises would be important to the jury, and the fact that he didn't is also important to the jury. Mr. Poole's question and other witnesses talk about field sobriety exercises as well. I think that the lead up on this is that, you know, it's going to be that Trooper Talton didn't do his job and request field sobriety exercises, and that's all this question's meant.
Well, if he had done that, then I might have allowed you to do what you did. The problem is, he hadn't even cross-examined him yet. I mean, I get that you were trying to head that off, but if Mr. Poole had stood up and said, you know, you didn't do any field sobriety tests, well then, heck yeah, I would have let you do that. But the problem is he had not done that.
She said, heck, he really got her riled up.
I think he went too far. I think he went too far, having reviewed Ammons, because it is still evidence of refusal. And I understand that you disagree with that ruling, but I think that you've gone too far. The question I now want you to address is the mistrial. And Ms. Williamson, I'm going to allow you to step in if you want to, and to assist. Because the jury's not in the room.
Okay. I mean, the only way, right, to kind of get around situations like this is to do a curative instruction. I guess the question is whether a curative instruction would be sufficient to unring, to whatever extent, the bell. And that's, I guess, why it's called a curative instruction. Whether it would cure them hearing that, and specifically, I guess, how we would word that if Your Honor were inclined to give a curative instruction, that testimony should be stricken from the record. It should not be considered.
Because the danger of a curative instruction is that you start
highlighting
something for the jury. What's the standard on a motion for mistrial? Anybody want to jump in there?
You've tested me on this before. And I want to say...
Manifest injustice?
Right. And then, of course, my prerogative is to always kind of go to a more knowledgeable mind than mine. And so I don't know if Your Honor would give me a short leave to consult.
I mean, I understand that y'all disagree with my ruling, but maybe the problem is, I understand that Ammons says the refusal is inadmissible, but when you put in evidence that tiptoes right up to the refusal, I think you're splitting hairs in a very dangerous way. And so I don't think that evidence should be allowed. Now, again, if Mr. Poole had bullied Trooper Talton about that, then I think that would have been an opening door, but we weren't there yet. So I don't think that evidence, those last two questions, should have been asked and answered. And I don't think that that's admissible and appropriate for the jury to consider. Mr. Poole has made a motion for mistrial, and I have to make a decision whether or not a mistrial is necessary or if we can get by on a curative instruction. Mr. Poole, I'm going to give you now, because I haven't, a chance to be thoroughly heard on the issue.
Thank you, Judge. And I agree with the court's propositions and the ruling. I think respectfully, and I'm not trying to be offensive to anybody, but I think it was in violation of the court's order, and I agree. The problem with the first step typically would be a curative instruction. The problem is that bell's been rung, and then my concern is the same as what Your Honor pointed out. Is I think bringing them in just to say, hey, we just talked about, or you just heard about field sobriety, and the fact that she was asked to do it, and that the officer, at a minimum, that she was asked, and that the officer wasn't able to conduct fields. I mean, to be able to give a curative instruction by necessity requires us to highlight the issue. And I can't say, I don't believe there's any way that that would be a fair trial for my client, Judge. And I'm looking just briefly, and
I said manifest injustice, I meant manifest necessity.
And that's, I agree. And I'm just skimming as quickly as I can, but I will say I do see a quote here, and I'm looking at Daniels criminal trial practice.
Okay, and I'll tell y'all, I'm looking at Rios versus State, which is 311 Georgia 639. It's a felony murder case. It's fairly recent.
And this quote that I see about curative instructions is, it says, where inadmissible evidence has been introduced and curative instructions cannot free the jury's mind of prejudice, a trial court should declare a mistrial. And that quote, and that's a quote within Daniels, and it's quoting to Bentley versus State 262, Georgia App 541.
One thing I want to point out real quick, guys, is so recently we just saw 2 other trials with this judge in this courtroom. This is the same jury that was the jury on those 2 other trials. This was like a trial week. And this jury has already sat through, things like this. So it's not like this isn't the first time for this jury. It's been a long week of trials and things like this for them. This is the last trial for them.
And I do submit that as a practical matter, I think a curative instruction would not free their mind of any sort of prejudicial thought or free their mind of what they've heard. And also, we'll state that a mistrial is a proper remedy when fundamental unfairness in the proceedings has occurred. It's the first sentence in that portion of the book, and that's not a direct quote, but the book cites to Sharp versus State 272, Georgia 684. And I would submit that to proceed after that would be fundamentally unfair and probably a violation of due process for Ms. McCarroll. And I don't think a curative instruction would free the jury's mind. I will also, one other small thing to point out, it's not that small, but I didn't object. When video was being played about the refusal for blood, the video kept going beyond where it was played yesterday. And I didn't object because I didn't want to highlight the bell, and it was stopped before the really problematic portion was played, but it continued to play through the troopers asking a second time, will you submit to, and that's where he goes in to ask for a breath test.
I didn't hear it, though. I heard him just start to reread it, is what I heard. But tell me specifically what you think he said.
This is at the time of the blood request refusal.
Right.
He asked for blood. She says, no, I'm afraid of needles. And then, kind of immediately thereafter, he says, will you submit to, and then it's paused at that point.
Right.
And I didn't object, and that was by design. But
Bobby's talking about a completely different case and a completely different trial. So this trooper is not his trooper. Ugh.
I only bring that up to say, I know that they hear that. I know that raises questions, and then that followed by this particular issue, it compounds. I don't think this issue needs any compounding, but I do think that that's a little bit problematic. But then when you add it on this, it's significant, and I sincerely don't believe that there's any other cure other than to retry it. I hate to say it, but that's my opinion, Judge. I don't think a curative instruction would be fair or sufficient in this particular case.
Of course, having reviewed the law on this a couple times over the course of my career, mistrial is it's the nuclear option, right? If there's any way to avoid a mistrial and still protect Ms. McCarroll's rights, that's what I should do. So under Rios, under the manifest necessity standard, a mistrial is appropriate where there is a high degree of necessity for declaring one. Whether such necessity exists is to be determined by weighing the defendant's right to have her trial completed before the particular tribunal against the interest of the public and having fair trials designed to end in just judgments. And the decision must take into consideration all the surrounding circumstances. Trial courts are to exercise a sound discretion on the subject, and it is impossible to define all the circumstances which would render it proper to interfere. Although the trial judge is not required to make explicit findings of manifest necessity, nor to articulate on the record all the factors which informed the deliberate exercise of its discretion, the record must at least show that the trial court actually exercised its discretion. And although trial courts should give careful, deliberate, and studious consideration whether the circumstances circumstances demand a mistrial with a keen eye toward other less drastic alternatives, the court's rejection of other alternatives is a proper exercise of the court's discretion and not an abuse if reasonable judges could differ about the proper disposition. So I'm considering a couple things. One, I think the fact that there were 2 questions about it is an aggravating factor. But the fact that it did not actually come out that she refused, but it did come out that she did not do them, and the reason for that is ambiguous, is weighs in the other side. Looking, at the totality of it, it does not seem so prejudicial as to require a mistrial. But I believe a curative instruction would sufficiently protect Ms. McCarroll in this situation. What I am inclined, and I understand you won't object to that, and I'll let you preserve that, Mr. Poole. Understanding you do not think a curative instruction is sufficient, and given your concerns that you think it would highlight it, I'm going to give you both an opportunity to weigh in on the curative instruction, which is what I'm going to do, which is just my thought is that the jury will disregard the last 2 questions and answers. And then I'm willing to say you cannot consider or hold against Ms. McCarroll in any way whether or not she submitted to any field sobriety exercises. But if you don't want me to mention that, I won't. But
Yes, Judge, and I, just for purpose of the record, respectfully object to the ruling.
I understand.
Understand the ruling. But I guess from a curative perspective, I would ask that that the jury be directed not to consider, I think a proper curative instruction would be the jury is not to consider refusal of anything as evidence of guilt, or any defendant to refuse as evidence of guilt, and not to consider the last questions or answers, and to inform them that the questions were improper and against the court's order. I'll leave it at that, Judge. Whatever else Your Honor thinks is appropriate, given the court's ruling.
all right, do y'all want to weigh in on the curative?
Your Honor, yes. I don't want to highlight the issue too much. I don't want to create a further issue down the line on it. But there are multiple inferences that can be drawn from the 2 questions that were asked. I think that highlighting what those inferences may be, I'm not sure the best way to weigh those. There are many reasons somebody wouldn't do the fields. Not saying that by instructing the jury that there's reason, or that can't be used against her, it kind of highlights that on the one side. But there's other reasons somebody wouldn't have done fields, Your Honor. The officer could have decided they weren't appropriate. There could have been physical issues with the fields. Could have been a number of things. And I understand we're splitting hairs here.
Well, and the problem is that wasn't the truth in this case, right? And so I want you to tell me, give me what the state is asking for as a curative instruction.
I think just disregarding the last 2 questions would be fine. If they're called improper, that wouldn't hurt my feelings, taking my credibility with the jury.
Just disregard.
I was just going to say that we're in violation of my prior ruling. So what I would say, but I'm willing to say more, is before you went out, there was an objection interposed by Mr. Poole. His objection is sustained. You are to disregard the last 2 questions and responses from the witness as they were asked in violation of the court's prior ruling. Now, I would consider saying something like the jury shall not infer anything or hold it against the defendant in any way if she did not submit to field sobriety tests.
Or, I would like
something else.
Well, same sort of train of thought, but if I may, just kind of one other point is I mean, I cannot imagine another purpose for the question other than to infer or to convince the jury to infer she refused to do the testing. I mean, I sincerely, I mean, and maybe the state can rattle off several, but I mean, what other inference would the jury draw other than I asked her for it, I didn't get them? I mean, the only plausible, logical explanation I can think of is that she declined to do it, especially when it immediately follows the refusal of the blood test request.
Right.
And so I respectfully just kind of renew the objection and renew the motion for mistrial based on that. But also a lot of our line of questioning and jury selection and the presentation thus far is based on the ruling. And that all obviously has just been totally kind of shot. And I think if the sole inference that could be drawn from the question and answer is she refused, then
I just don't love telling them that she refused. But
Judge, can I respond?
I'm just making
Once he's done.
a legal argument about more. I'm circling back to the motion and objection. Just making a legal argument. The state says, well, they may have not gotten it for any number of reasons. And the state actually argued, I think.
Sir, she ruled. She ruled on this. Give her jury instructions. That's all you have to do right now.
Well, there are many reasons why someone would not take the test. Well, that's maybe, but all of those point back to the person didn't take the test, and
Right.
that's the whole problem.
Yeah, I'm with you, Mr. Poole, on that.
And so, and then also just about jury selection, the line of questioning asked there based on the court's ruling, the entire presentation thus far, and we're almost done with trial, has been limited to the court's orders, but for, just, like an inexplicable and still unexplained violation of the court's order. And it's just.
Okay, well, I got what you're saying, but I really want to focus on this curative instruction. So what, if anything, would you want me to add?
The only sort of change to what the court just mentioned would be, the defendant, or the burden never shifts to the defendant to present any information or evidence or provide any evidence, any lack of evidence or anything like that.
I'll charge him on burden of proof if you want.
Something along those lines, Judge, but just that the defendant never has to produce evidence or provide evidence, and that cannot be used against the defendant. The state's got to prove.
I love something pattern. Okay, so you don't want me to say anything about the jury shall not infer anything or hold it against the defendant in any way. You just want me to say something like, disregard the last two questions and responses that were asked in violation of the court's prior ruling. The burden of proof, this defendant is presumed innocent. The burden of proof. I'm gonna give you a chance. I just want to get through this. Okay.
I'm fine with the first. I like the first clause Your Honor read out. I just didn't. The last portion for the court's proposed language I thought was whatever you just said again, Judge, like not to hold that against the defendant. But the part I didn't like was about the refusal. So I like the clause about don't hold that, because to me it speaks to the objection itself and or cause, and then roll into the burden of proof and whatever language Your Honor thinks is appropriate from that. But I think hopefully I'm being somewhat clear about what I'm trying to convey.
Okay. I know y'all want to respond, and I'm going to give you a chance. Just, I'm trying to write words. I'm going to say.
And also okay, remember, so this is the third trial we did this week with this judge. Wasn't this prosecutor, wasn't one of those trials his very first trial? I think. She's training him. She does have a pretty voice. I think she'd make a good teacher. Little kids. Oh no, she just whipped out a heck earlier. Forget it. She can't be around children.
All right. I think I have myself together enough to hear the response from the state. Y'all go ahead.
So I think the state is taking the position that I guess there was no violation of the court's order. I guess an interpretation of Ammons is that the refusal cannot be used against the defendant. And I guess in Mr. Elliott asking the question, he's, I guess, trying to do it under the thought process of Randall, such as with a refusal with a blood test, which is to explain that I guess the officer did, I guess, his job. And so that is our contention, Your Honor. So if Your Honor were, I guess, to interpret the case law the same way, then there would not be a need for a curative instruction. That Ammons, let's see, I guess it's also in like the same time, obviously, as Elliott and all of that case law, that it's that the refusal cannot be used against them. I guess in the inference that had they, being that they refused, you can infer that it would have been positive, like the jury instruction, right?
Right.
So, so if we're just bringing up the fact that he tried to do the field sobriety test, that he was simply just trying to do his job, then the argument would be, I guess, falling more in line with Randall.
And I understand that argument, Ms. Williamson, but I'm ruling against it, and here's why. You know, it's like when you read Miranda and someone invokes, you don't ask the question because, and that's how I've always interpreted that law. I mean, you know, now if the defense says, well, you never even tried to question my witness, well, then you're my client. Well, then I think you're in a different spot. And I understand what Mr. Elliott was trying to do, and I don't think there was any bad faith, and I'm not making any finding of bad faith, but I'm not going to allow that evidence. Now, I've denied the motion for mistrial, and I'm going to give curative instruction.
Judge, is there language that you can do that would say under the current status, the state of the law, the defendant is allowed to refuse? And that takes all of that sting out, like, because that is, they are allowed to refuse.
What do you think about that, Mr. Poole? I mean,
Well,
I would only do that if you wanted me to. I
think that's right for closing argument. I think there's a constitutional argument there to be made in a closing.
I get a little, I mean, I understand what your argument is, Ms. Grant. I get a little uncomfortable making too much comment here because I don't want to comment on the evidence in any way. Here's what I've written, and I'll give you all guys plenty of chance to respond. Before the break, an objection was interposed by the defendant that was sustained. You are to disregard entirely the last two questions and responses from the witness as they were asked in violation of the court's prior ruling. You, the jury, should not consider that evidence in any way, infer anything from it, or hold it against the defendant in any way. The burden of proof in a criminal case rests with the state, and that burden never shifts to the defendant to prove innocence.
I'm subject to prior objection.
Yeah, I know nobody loves my ruling. I understand your positions, but
that curative instruction is as good as anything I can think of, Judge, better than anything I can think of. And the only other thing, just quick responses. I understand the state's interpretation of case law, but the issue at hand is the application of the court's order from yesterday. The order and presentation and proffer of the parties was we weren't going there. we were not going there at all, not going to talk about refusals of fields. And then all of our questioning, obviously the entire presentation up to this point was consistent with that. So
Well, and I, I take some blame for that, Mr. Poole, because maybe I wasn't as clear as I should have been with everybody about what I thought the agreement was, and I should have probably nailed everybody down a little tighter about that. And so to some extent, I'm willing to eat that a little bit. But I think maybe I just, I was a little loose about that more than I should have been.
Who thinks the jury remembers the last two questions and answers? Nobody.
Because I thought we were all on the same sheet of music, and clearly we were not. All right, let's bring in the jury. You understand my ruling?
Of course.
Okay. Y'all can have a seat when you come on in. The lawyers stand up as a sign of respect to you, but y'all can have a seat. All right, and everybody in the courtroom may be seated. All right, members of the jury, I apologize for the disruption, and I appreciate your patience. Before the break, an objection was interposed by the defense that was sustained. You are to disregard entirely the last two questions and responses from the witness as they were asked in violation of the court's prior ruling. You, the jury, should not consider that evidence in any way, infer anything from it, or hold it against the defendant in any way. The burden of proof in a criminal case rests with the state, and that burden never shifts to the defendant to prove innocence. All right, with that, Mr. Elliott, you may ask your next question. Or if you wanted to go to the video, I can.
If we could just roll the video, Your Honor.
Okay, where are you beginning at?
I believe 2841.
Okay, and my screen is black. Do you need to?
I need to plug in.
28.
It says 41.
Okay, you had said 2852 previously, I thought, but maybe.
I think it was going to be 2845 was the target, but whether it's a couple seconds, either way, it doesn't matter.
So I actually just did it a little bit later.
Okay.
So 2851.
Okay, 2851, thank you. All right, you may proceed.
Yes.
All right.
No air in that.
Okay, listen to me.
Can you tell me what I've done wrong?
Listen to me.
Yes.
What do you want to do with your Jeep? Do you have a friend you want to call to come leave it with?
Yeah, can I? I'm still just taking in what I don't understand what I've done.
All right, well, look, you're under arrest for driving under the influence, all right?
But I was not driving.
You want to, listen, you want to tow that Jeep and you pay $300 to get it out, or you want to call a friend?
Can I call a friend?
Yes.
Can I have a cigarette?
No.
Please.
No. Grab your phone and call your friend. Is this your friend down here?
I'm going to call him.
Okay.
I don't understand. I don't understand. How was I driving? Can you please the person want to say the code? How was I driving up here?
Is this your friend you called on the boat?
No.
Okay. I mean, don't call somebody in Woodstock or nothing. You got time to wait on that.
No.
Okay.
How was I driving up here?
Get somebody on the phone.
I thought it was great. This is really happening. Is there any way they can also meet me there and get me bailed out right away, or no?
That'll come later down the road.
You're right. I cannot believe. How am I getting arrested for driving impaired? Can you explain that to me? Okay. I did not. This is not. Okay. That's kind of a setup, and I have to deal with it. You want to take a cigarette, right?
I didn't say you could have a cigarette, Mr. Carroll.
I know you didn't.
That's right, so put them up. There's no need to open them, all right?
Obviously, no. What if I just... Did I admit to hitting you and we let it go? No. He's just gonna keep doing this. just moved back here a month ago. I'm trying to think of who to call.
It has to be somebody here. We're not waiting for somebody to drive down here, okay? I thought you knew somebody that lived on a boat over here.
I do. Well, yes, I do.
All right.
I can't call John, the guy who.
I don't know. I listen to the wind, and I feel like I'm on a boat, so I like it.
Did you guys actually talk to the waiter waitresses at there to understand what I was doing with him? And they saw the water and everything we drank?
I just pulled up here. I haven't been down there.
Can you do, what if you do that? And you'll understand I drank 3 waters. I gave him 5. Like, I was there for him. Is there any way he can, like, I don't understand why I'm the one being arrested right now. Is there any way? Alright, so I have to call my mom.
All right, well, let's give up on that. We'll figure out something else to do with the Jeep, all right? You want to take the phone with you?
No, it's good.
Huh?
Can you just,
Do you want to take the phone with you?
I do.
Let me have it then.
I do, sir. I do, sir. One second, let me.
Leave that in there.
Alright, they have the keys?
Huh? Keys laying right up there.
Alright, I'm not starting the car. Well, I am. I'm
No.
gonna open the windows.
No, let me have the keys.
Okay.
Come on. Leave that in there.
Okay, and then as far as my purse, it does have cash. Do you mind if I put it in my wallet and then take it out?
You want to take your wallet with you? Make a decision, yes or no. You want to take your wallet with you or not? Yes or no?
No, I don't know.
All right.
I'm really getting arrested.
Come on back over here.
Okay, we leave the purse in the car.
Leave the purse in the car.
Okay, and the jacket. Say,
Leave the jacket in here.
Mom, I'm really getting arrested.
Yes, you are. Come back over here. Come over here, Mr. Carroll. I got your wallet and your phone. Take it in with you, okay?
But I do want to ask him how I'm,
Stand by your back.
when I was not driving.
What's the call right now? Get up right now.
Maybe call one more person before we go.
No.
They can meet us at Hall County?
No, you can call from the jail, okay?
They won't let me do it for 2 hours. Can I please call my mom?
Not right now.
Can you please start the car, lock it, and roll the windows up, please?
There's a lot. They're not going to get any tighter when you just pinch and adjust your wrist. Clear? Come on back here. Over here, over here. You need to sit a little sideways or something to make it comfortable. You can.
Well, Mr. Patience. You got a lot of patience. Dude, I give you props for that. Patience.
I learned long ago.
She got someone coming to pick it up.
She couldn't get hold of nobody, no.
So we'll tow it.
If you want to, yeah.
All right.
Y'all gonna handle that and do the inventory on it?
I'm still on the boat. I don't know what you're talking
I'm gonna
about.
take this. She has money in it, so.
Appreciate you coming out.
I'm sorry. Go ahead. Sitting over and over, we'll just wait.
What's all happening? Yeah, that, like I said, that, the bartender said she served 2 Jaeger doubles.
Jaeger doubles.
That was over about last like 2 hours. Yeah, the guy heard the guy share like an hour.
So they just getting a dispute about somebody driving?
He was worse than she was.
Oh.
He was worse than she was. But he got her, she got his keys from
I don't know which one it was, but she backed into the officer's car. She backed up and hit a police cruiser. But it's a big deal for this specific officer to have someone hit his car. So we're going to find out in a minute why.
and wouldn't let her drive. And then Uber showed up. He just wanted his keys back. So she's like, well, I'll leave your keys. So I got her his keys back, gave it back to her, gave it back to him, and he didn't want to press charges for stealing keys. He just wanted her Uber shit. So all that was just pretty much the show. But yeah, he was worse than she was. He just thinking, insurance and valid driver's license.
All right, guys.
All right,
I'll leave y'all with it.
Thank you.
All right. Pick it up. Should be hard. Yeah.
All right. We're good.
All right, guys. I got your phone and your wallet here, Mr. Carroll.
Thank you. I know, but is there any way you can help the process to get bailed out only because my dogs are at home?
Once we get you out there, they'll let you know what the bailout process is.
I can do it, but
Okay, well, I don't know that process.
Okay,
You have to wait till we get to the jail, and they'll walk you
Okay.
through every step of the way.
okay. And can I watch them roll up the windows and lock them, and you have my car keys too?
Well, they got the car keys.
I know. Can you grab them so they go in my jail stuff?
No, but the
Can they-
tow truck driver has to keep those. So he
no,
can
my
put it
kid
in.
can stay here.
No, man, we're not allowed to leave vehicles sitting here.
Okay. So where am I going?
Hall County Jail.
Okay. But I still don't
I don't
understand.
know
I was
what
not
they are.
driving.
Mr. Carroll, you'll have an opportunity in court to come tell your side.
Okay. All right. Yeah, I gotta go to jail for 12 hours.
No, she's
Can you please
actually,
at least watch them roll me?
she's actually not going to jail for 12 hours at all. But she's going to jail.
I trust you.
Trust me, they'll take the record driver. He'll take care of it. He'll have
No,
the keys.
they have the keys. Can you
They'll
actually?
give them to the tow truck driver.
So you're not gonna watch them do it?
No, I'm not.
Stopping at 3944.
Trooper Salt, based on your interaction with Ms. McCarroll, did you develop the opinion that she was impaired by alcohol?
Yes, based on my interactions with her and all the events that happened in the scene, speaking with the deputies, I determined she was under the influence of alcohol.
All right. What factors did you consider when determining she was under the influence of alcohol?
First factor, she backed up from the parking space, hit the deputy's vehicle that was behind her. The deputy's vehicle, according to what I was told, had blue lights on. According to what Ms. McCarroll said, she saw blue lights. The deputy's vehicle was positioned at an angle that if she had just looked at her driver's side mirror, she would have seen the side of the deputy's vehicle. If she had perhaps turned, looked over her shoulder, she could have seen the top of the deputy's vehicle as it was an SUV, so it obviously sits up more than a passenger car would. When I first spoke to her, I noticed the odor of alcoholic beverage on her breath. She admitted to having 2 Jaeger bombs at the bar earlier, along with 3 waters. The 3 waters seem kind of quizzical. I've heard before that there are persons who believe they're
Objection,
consuming
hearsay,
alcohol.
and speculation.
I think that we're getting a little narrative. Why don't you just ask another question?
Yes, Judge.
Can I just continue to skip that?
Would that be all right, Judge?
Just, why don't you just ask another question? To direct him a little bit more.
All right. Did Ms. McCarroll's demeanor play into your decision or into your deciding that she was under the influence of alcohol?
Yes.
All right. Was it amongst other, did her changes in attitude play into that
Yes.
decision? Did her talkativeness play into that decision?
Yes.
Did her swings between aggression and compliance play into that decision?
Yes.
Did her admission to consuming alcohol play into that decision?
It did.
Did the knowledge, or did the report that she had consumed 2 double shots of Jaeger play into that decision?
Yes.
Did her denial that she was driving play into that decision?
I'm sorry.
Did her denial that she was driving play into that decision?
Yes.
Did her constantly repeating herself play into that decision?
Yes, constantly repeating, asking some same questions over and over.
All right. And as well, the fact she backed into a patrol vehicle played into that decision.
Exactly.
All right. Based on that information that led you to believe that she was under the influence, did that same information also lead you to believe that she was less safe to drive an automobile?
Yes.
Is there anything else that I haven't mentioned that played into your decision that she was under the influence of alcohol to the extent she was less safe to operate a motor vehicle?
A couple things that came to mind. She had an urgent need to go to the restroom, and she was, kept wanting a cigarette.
He just told the jury that he thought she was under the influence of alcohol because she had to go to the bathroom and she wanted a cigarette in a very stressful situation.
What did anything about the restroom have to do with whether she was under the influence of alcohol?
I believe it's common knowledge that consuming alcohol makes one have an urgent need to urinate.
All right. And then what about the cigarette?
What about 3 waters? Does that do anything?
Cigarette was important.
Just used by intoxicated people to try and cover up the alcohol in the breath.
I'll pass the witness, Your Honor.
Cigarette smokers are more likely to be DUI, is that correct?
I have no idea about that.
Your testimony just then was that people smoke cigarettes to cover up their breath as a common tactic, right?
I've seen it a lot, yes.
Okay. What about cigarette smokers that don't drink?
I don't have any statistics on that.
Okay. I mean, you would agree people might just smoke a cigarette because they have a craving for a cigarette, right?
I wouldn't know in this case. Mr. McCarroll had been drinking, so I can't state that.
That's not what I asked you. The question I asked you, Trooper, was you would agree that people that smoke cigarettes might choose to have one or ask for one simply because they have a craving for a cigarette, right?
They may.
Okay. Is that difficult? Like, is that difficult to answer or difficult to just say, like, yeah, cigarette smokers might want a cigarette?
Well, no, I thought we were talking about Ms. McCarroll, someone who's been drinking, wanting a cigarette.
Okay. And obviously that's an indication that she smokes cigarettes, right? If she's asking for a cigarette and has cigarettes on her person.
Obviously.
Sir?
Obviously.
Okay. And so then you would agree that it's just as possible that she's just asking for a cigarette because she's got a craving for a cigarette.
Well, that might be a question only she could answer.
Okay. Only she can answer the possibilities of what cigarette smokers might want.
What she might want it for, not everyone.
Okay. You made a report in this particular case, right?
I made an incident report and a crash report.
Okay. And it's important that reports are true and accurate and complete, right?
Yes.
And you did that in this case, correct?
Yes.
And you just testified about the manifestations of Ms. McCarroll being impaired, and was that she hit the police car, right?
Yes.
Admitted to consuming alcohol,
Yes.
wanted to go to the restroom,
Yes.
and wanted to have a cigarette.
Those and others.
And slightly bloodshot eyes is your testimony today, right?
Yes.
And then her demeanor.
Yes.
Anything else?
Her confusion.
That'd be part of her
Kept asking.
demeanor, right?
Over and over. Am I under arrest? What's going on? I don't understand. Her use of profanity.
Okay. Her use of profanity, so curse people, somebody that cursed is an indication she's probably under the influence to the extent she's a less safe driver. Is that right?
Well, based on that testimony, then, Bren, yes. I was drunk every day for the last 50 years.
Profanity is sometimes used by intoxicated people who are unsafe to drive.
Okay. And because that is sometimes the case, that is one of the factors that you looked at in making your charging decision. Is that correct?
Yes.
Okay. And any other factors, so her asking repeatedly, am I really under arrest? Anything else?
There was one incident in the video. You can hear a shout back to the deputies, if I admit I did it, can we just let it go? Which indicated to me she knew she was intoxicated and was hoping to get out of the charge.
Okay. So your testimony is that comment that we saw in the video, her saying, hey, if I just say I did it, if I admit I hit you, can we just let it go? That's a sign of her impairment to the extent she's a less safe driver. Is that correct?
It's a sign that she knows that I know that she's an unsafe driver.
Okay.
She knows.
Her comment to
I
another,
know.
to a deputy on scene is an indication of what she knows you know. That's your sworn statement.
She indicated to me that she knows she's unsafe to drive and that I've determined that by being around her.
And she indicated that by making this statement to another deputy. Hey, if I just admit it, can we all just let this go?
Indicate that.
Bobby, I don't drink, smoke, or swear. Damn it, though. I left my cigarettes at the bar.
Cater to me.
Okay. So I want to sort of circle back around because I feel a little sideways on this. I want to make sure I understand. She tells the deputy, hey, if I just admit I hit you, can we just let this go? And you take that to believe that Miss McCarroll thinks that you think she's a impaired driver, that she's DUI to the extent it's left safe.
Well, that statement and everything else that's occurred up to that point.
Okay.
Not that alone.
So you were able to draw the conclusion based on the factors and based on that comment of what was going through Ms. McCarroll's mind about your brain in that instance. Is that right?
Yes, I believe she had figured out and she knew she was less safe and that I knew it.
Okay. Because DUI less safe is, you know, everybody knows what that means. Is that right? And loads of people have heard that term around the state in your experience. Is that right?
Well, I can't speak for everyone if they
know
the meaning of that.
Okay. And you testified today her eyes were slightly bloodshot.
Yes.
And you put in your report bloodshot, right?
Yes.
And yesterday you testified bloodshot, right?
Yes.
And yesterday I didn't tender that picture into evidence, did I?
No, you didn't.
And so only after presenting a picture of Ms. McCarroll's eyes bright white do you say now that they're slightly bloodshot. Is that correct?
Yes.
And you criticize that photograph because the angle's not right. And
he took that body cam video that we just watched yesterday and blew up her eyes to try to see if she was bloodshot. And the angle was bad and blurry. And so I don't know why he's bringing that up again because it was very good. Monica, thanks for the cheers. Thank you so much.
Whatever else the case may be, is that correct?
By looking at it, yes, there's several things I noticed.
Okay. The angle of the possible whiteness in her eye changes the color of the whiteness. Is that right?
I don't know if it changes the color of the whiteness. It may not pick it up as well as a direct on view.
So the angle may not pick up the colorations as well. Is that right?
Correct.
Of that slight redness.
Yes.
And you said that the picture wasn't close enough. Is that right?
It's not as close as I got to her.
Okay.
With my normal vision.
And you were here all day yesterday as well, right?
Yes.
Just like the other officers you've heard testify today, right?
Yes.
And you've got access to all of these state's videos that have been presented so far, right?
The only video I've seen is mine. I haven't seen any of the deputies' videos.
But you've got access to it. You're the lead officer on this case. You're the investigator that gets to sit at the table, right?
Yes.
Okay. And so you could have just as easily went and gotten, in fact, you've been here all day, even after I tendered that picture this morning, right?
If I had needed those, then I probably could have gained access and looked at it.
You just said you had access to them, right?
No, I said I have access to the state videos that I made. I don't have direct access to any deputies' videos. I would have to request and get a copy, much like anyone else would.
Sure. You have to ask the people that you're sitting right next to, hey, can I see that? Can I get that?
I could either ask them or someone at the sheriff's office.
Okay. And you could have, you could have done that. You could have, sitting here, you could have gotten a better picture that showed redness of the eyes, right?
Well, I don't know. I haven't seen all their videos.
Okay. You have heard this testimony about slurred speech and unsteady on people's feet, things of that nature. That you would agree those are typical DUI manifestations, right?
Not typical. There are things you look for, though.
Okay. And would those be, okay, if those are things you look for, what else would you typically look for a DUI driver?
You look for those. Their understanding of you talking to them, their mannerisms, how they talk, how they move. Are they still? Are they moving around a lot, waving their arms? Do they understand what you say? Admission to drinking, alcohol in the vehicle, perhaps, odor of alcohol in the breath.
Okay.
Any kind of confusion, profanity, things of that nature. About what we discussed here.
Okay. And you didn't annotate slurred speech or unsteady on her feet or waving her arms or using her arms or stabilizing herself or anything like that in the report. And obviously that's because that's not present in this case, correct?
Right. It's something you look for. It's not always present.
Okay. And you talked about her, sort of being argumentative, crying, and talkative, her behaviors that were alarming to you, right?
Yes.
And the only time that she cries, as you've seen, is after she's arrested and immediately after discussing her friend that was suicidal that day, right?
There was at least 1 or 2 times maybe she was crying. I can't remember. I think maybe it was very subtle. One moment when I told her something or asked her something, it was very subtle to the point where she had to go get a paper towel and blow her nose.
Okay.
Wipe her eyes.
Okay. And that was at the time you said, yeah, a runny nose can be something, you made a comment about a runny nose with a pain or something like that, right?
Right.
Blowing her nose is not, I mean, is that an indication of DUI?
Oh, no. It's just an indication that if you cry, sometimes you start crying, your nose start running.
Okay. And she, as you've already testified, she told you numerous times she wasn't under the influence, right?
Yes.
And you testified one thing you said on direct with the state is that an indication of her impairment was the poor judgment she showed by taking the keys from that gentleman, right?
Yes, I believe that was mentioned earlier.
Okay. But then you told her in the video, that's all right, that's a good idea if he's not safe to drive, right?
To take his keys?
No, I'm asking what you said in the video. You told her that day, when the jury's not sitting here, you told her, that's all right, that's a good thing to not let somebody drive when they're not safe to drive, right?
Yes, but I don't think I was aware she had actually took his keys and left with him.
Okay. And so, but you're aware of that now, right?
Yes, I'm aware of that now.
Okay. And so because she took his keys and left him, now it's poor judgment. She should have just let him have his keys and parted ways with him.
Well, it was my understanding that he had an Uber coming, and an Uber had arrived, and once he was in his Uber on the way home,
okay,
provided his keys back.
And your understanding is the same thing we just heard Ms. McCarroll told you, she contacted the Uber, correct?
No, I believe the bartender stated that she used the gentleman's app and contacted Uber, not Ms. McCarroll.
I know you heard that testimony today.
Yes.
But what I'm asking is about the evidence you received that day in question. On the video, Ms. McCarroll said, I contacted Uber, right?
I don't recall if she said she actually contacted him. I believe you're correct, though, that she did, which would contradict what the bartender testified to.
Okay. And I mean, obviously, just like you and every other officer, myself, and anybody on the planet over the course of 2 years is going to forget these little details, right?
Perhaps.
And to that point, we talked yesterday, and in your report, you've got on there that the deputy's lights were on when he pulled in behind Ms. McCarroll, correct?
That's what they had told me, yes.
Okay. And you heard the testimony he testified today saying that was mistaken, and they were off at that point, and he went and turned them back on, right?
I believe Deputy Bryant stated he turned them on and believe he may have accidentally turned them off when he got out of his vehicle, but then went back.
Well, that's what he says in the audio, but his testimony was that they were off and he went back and opened the door and turned them on. Do you agree with that?
I believe that's what he said.
Okay. And in your report, you've got that they're on, and we've talked through this, but the jury hasn't heard it. But whether they were on or off, in your opinion, doesn't impact the driving issue, correct? Or being the at-fault driver?
Correct. The vehicle was, the deputy's vehicle was still behind Ms. McCarroll, lights on or off.
Okay. And who bumped into who at that point was really not relevant for your purposes, or who caused the accident, other than changing the driver 1 and driver 2 on the accident report. Is that fair?
No, it is important to determine who hit who, as if one driver is intoxicated, that could be a contributing factor, being intoxicated.
Okay. And so, and you testified today that she could have turned around and looked and seen the car there, or looked at her driver mirror, but as we covered, passenger mirror, she could have looked out and not seen the vehicle because of where he was parked, correct?
But that was, yeah, likely so. It would have been probably difficult to see out the passenger window. If you did see it, it might have been very minute.
Okay. And your testimony yesterday was, wouldn't see it, right? Like, because it's that.
Right, yeah. The way he was parked, she likely would have seen the front corner or anything of the vehicle.
And the same for the rear view mirror, because her Jeep is fairly lifted and just the hood was on the back of the car. And so moderate chance that if she'd used the rear view, she wouldn't have seen him at that point either, right?
Once again, that's be a question only she could answer.
Well, I'm not asking you that. I'm asking you based on your knowledge, training, experience. And I mean, you testified about this yesterday, right?
I did.
Okay. And so just based on your knowledge, training, experience, and I don't know, basic rules of looking through a rear view mirror in line of sight, I mean, you would agree that rear view is up over the height of where that hood would be if it's immediately behind the Jeep, right? I mean, your testimony yesterday was...
No, I don't know. I mean, it'd be speculation. Anyone look through that rear view mirror in the back might not see the hood, but the deputy's vehicle is an SUV, which sits up. and has a light on top and should be visible through the rear view mirror, or if someone turned and looked over their shoulder.
I understand if she turned back and looked, but could you agree pretty unlikely that she would have seen it through the rear view?
Well, I don't know. That's a question only she could answer.
Okay. Did anybody sit in there and look to see that line of sight or that angle when doing the accident reconstruction or coming up with the diagrams and stuff?
No, because Ms. McCarroll had actually said she saw the blue lights and then backed up.
Okay. And we've all heard a little bit today about who should have inventoried the car. You've heard officer after officer after officer say you, because you did the report. But you agree, based on the video, that they actually committed to doing the inventory, correct?
Yes, I noted that in my incident report. They had the vehicle. They conducted the towing and the inventory.
Okay. And you testified about, one indication would be obviously open containers within the vehicle, right?
Yes.
Were you ever made aware of, prior to today and seeing the video and stuff today, you were never told that she claimed that she threw away a to-go drink, were you?
Right. Ms. McCarroll never told me she threw one away.
Okay. She said she had 2 Jaeger bombs, right? Is that correct?
Correct.
And that would be the equivalent of a double, right?
Yes.
And when the deputies were describing her statements to you, they never told you she claimed she threw her second drink away, right?
Right.
And so you were unaware of that until this trial, correct?
Correct.
Had you known that prior to today, would that have impacted any charging decision for you?
I don't know. That'd be just speculation.
Okay. You, in your report, we talked about this a little bit. There's an indication that no, the incident didn't occur because of actual or perceived attributes to the driver, correct?
That's in a version of the report that I don't have, didn't have access to, and was not available at the time I printed my copy of the report or entered the information onto the report form.
Okay. But would you agree, yes, that's in there?
I agree it's in there, but I don't agree with it.
Okay. And so when you say I don't agree with it, the indication is the accident didn't occur because of impairment, but you disagree with that assertion. Fair?
Fair.
Okay. And you don't know how that ended up in your report?
No, I do not.
And the report is, only your report, is not like a joint report with somebody else. Your signature line at the bottom, correct?
Correct.
And since going over that yesterday, were you able to gather any additional information to explain how it's in your report that the accident wasn't a result of impairment?
Well, no, I've always determined that that crash was a result of impairment. Why the report that you have is different from mine, the only thing I would offer is that perhaps from the time I entered my report and printed it to the time you received yours, there may have been a software update where some information is added, which would actually print off for you.
What? What did you just say, sir? Oh, come on. Maybe AI did it.
But not for me. And since I did not have to enter that information when I did the report, it would likely automatically default to no.
Okay. Automatically default to no. And then like some of the other questions there that are missing from yours are the location type was a parking lot, right?
Yes.
And that the action taken was an arrest, right?
Correct.
And then number of weapons involved, 0. That's not in your copy of your report, correct?
Correct. From what I recall, when I was still working then, the only time you would list anything about weapons involved would be if there was a use of force, in which case there was none of this.
Okay.
It may be something new that's included on your report.
That I included?
That I have. I mean, that you have.
That I included on it, or that?
No, that's included in a private software update.
And I got the report, I mean, based on the information you received yesterday, I got this report from the prosecution. Is that fair?
I don't know where you got it. You mean you can go through our open records department and get the same thing, probably.
Okay. But you think that maybe the report indicates no, not caused by any kind of impairment because that's a default answer?
Yes, that's what I believe, yes. It's on there, but I disagree with it.
And is the parking lot description the default answer also?
No, I believe there is at the time, there was a location where you pick a location like a parking lot, public roadway, sidewalk, things of that nature.
Okay. All right, thank you. No more questions.
Trooper Tolson, do you recall there being a tire mounted on the back of the defendant's Jeep?
Yes, there was a spare tire mounted on the back.
Is it your recollection that that tire extended up into the rear window of the Jeep to some extent?
To some extent, yes.
Would you expect that a tire in the windshield would impede the view of a rear view mirror out the back of the vehicle?
Likely not intentionally. I would think that the tire was mounted probably as it came out of the factory, and that, of course, the view would be less for the driver to see out the back window.
But if it's at the bottom of the rear window, it'd cut off, what you might see out the bottom or the back end of the vehicle. Does that sound right to you?
Yes.
All right. You've seen semi-trucks driving down the road?
Oh, yes.
All right. Most of those don't have rear view mirrors, do they?
It wouldn't do any good if they had a trailer. They couldn't see out.
So if they had a mirror, they wouldn't be able to see out the back because they had a trailer.
They don't have the side mirrors.
All right. And so if the rear window's blocked off so you can't see out the rear view mirror, there's still side view mirrors to look out behind, correct?
Yes.
All right. There's a bit of dispute over whether the deputy's lights were on or off at the time that they pulled up behind Ms. McCarroll. The deputy, did he tell you one way or the other at the time of this whether they were on or off?
He told me they were on.
All right. And then did Ms. McCarroll also tell you that those lights were on?
Yes, she told me she saw them.
All right. Did the defendant tell you ever that she had one drink, bought another drink, took it out or took it to go, and then threw it away?
No, she never mentioned throwing one away.
Did she tell you she had 2 Jaeger bombs?
Yes.
All right. And you understood that those 2 Jaeger bombs were each a double serving of Jaeger?
Objection leading.
I'm sorry, did you understand that those 2 Jaeger bombs, or the 2 Jaeger bombs, were double servings of Jägermeister?
Yes.
All right.
I never heard her say bombs. She said she had 2 Jaegers. They kept saying bombs.
Did the defendant tell you initially and several times that she was not driving, but then as she was being arrested, did she call out to the deputies and say something along the lines of, if she admitted to hitting the deputies, would they just let her go?
Yes.
All right. Is it common for people who are getting arrested for driving under the influence of alcohol to try to bargain their way out of it?
It's common, yes.
All right. So talked about a photograph of the defendant's eyes a few different times. Not to beat a dead horse here, but would you say that it's what you see in person is more detailed than what you would see in a photograph?
Absolutely. Especially body cams and dash cams.
All right. Also a question about a different report with some attributes, a section of a different report where it said there were attributes, or the driver had certain attributes on there. Do you have a copy of that report that was being referenced?
Yes, I do.
All right. When you're looking at your report indicates that the defendant was under the influence of alcohol. Is that correct?
Yes, the incident report and the crash report are both noted.
All right. So 2 separate reports indicate that the defendant, or that it was your opinion the defendant was under the influence of alcohol.
Yes.
All right. The report you brought and you were referencing, did you print that report off ever?
Yes, it was probably within a week after I did the report, submitted it for approval.
All right. Is that something you commonly do?
Commonly do, yes. I go ahead and get the report printed up, get my case file started, especially on DUIs, because there'll be other administrative hearings likely coming up way before you get to the criminal part.
There was a conversation about a number of different factors that might have led to your decision to arrest Ms. McCarroll and to decide for you, at the very least, that she was under the influence of alcohol to the extent it was less safe for her to drive. Was there any one factor you relied on, or did you rely on all the factors together?
Oh, no, it's all the factors taken into consideration from the time I arrived till I made a determination.
All right. Is it common for you to look at a number of factors or just to look for one thing specifically to make a decision?
Oh, no, you always look for as many as you can.
And based on your observations, do you believe that the defendant was less efficient at operating a motor vehicle than she would have been had she not consumed the alcohol?
Objection. That draws a legal conclusion. That's what the jury's here to decide, Judge.
Do you want to respond?
He's making a determination if she's under the influence of alcohol to the extent it was less safe for her to drive. There's a number of ways that could be. Ask the question a different way. If it remains objection.
Okay, I'm going to sustain the objection. Ask your next question.
In what ways do you believe that the defendant was less safe to drive a motor vehicle? It's not the factors, but in what aspects do you think she was less safe to drive?
All the factors I've listed before, from her driving, her mannerisms, the odor of alcohol in her breath, admission to drinking, confusion, profanity, talkative, emotional, trying to be compliant, then argumentative back and forth.
So not the factors, but what do you think about her ability to operate a motor vehicle?
I do not believe she was able to safely operate a motor vehicle.
All right. I'll pass the witness.
Just a couple quick questions, if I may, Judge. And your report is different from ours because you printed yours about a week after the incident, correct?
Yes.
And you arrested Ms. McCarroll prior to, we heard that she declined a blood draw because of a fear of needles, but you arrested her prior to making that request, correct?
Yes, she was placed under arrest before I read the implied consent and asked for the blood test.
Okay. All right, no more questions, thank you.
All right, Trooper Talton, you may step down. State, call your next witness.
Your Honor, could I have a second to change files, please?
Yes.
Thank you.
Yes.
Afternoon, y'all. I'm going to talk to y'all now, and then I'm going to let Mr. Poole talk to y'all for a few minutes, and I'll talk to you again.
So the rest of the witnesses, all the other police that came up, how long were you in the academy? What was your training? Blah, 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 blah. They all said the same thing he said. So I skipped it, and now we're at closing statements.
I'm going to point out just a couple small things. Y'all are going to hear us both talking a lot, but nothing we have to say is actually any evidence in this case. We're just trying to point out the evidence that we think is important to you.
They did prove that he did not, in fact, have his lights on at all when he was behind her. He turned his lights on after she got out of the car, after she hit him. They did prove that she hit him. And then after that, then he turned his lights on. They did prove that they put things in the report like he had his lights on when he didn't. So the report that the officers all wrote, they weren't huge things, but they were not true. They were just slightly off. So that happened.
I encourage you to pay attention to the things that are important to this case. Ms. McCarroll is facing a charge of driving under the influence of alcohol less safe. So you're going to be looking to find out whether she had consumed alcohol, whether she had been driving a motor vehicle, and whether she was less safe to do so. I will tell you what less safe means just here in a little bit, but those are the things that matter. There's a lot of other stuff we talked about in this trial. And while it plays a factor into making decisions for the officers, and y'all pay attention to it too and use it as a factor in deciding whether you believe Ms. McCarroll was under the influence of alcohol, it matters. Just pay attention to it. But there's three things you got to decide. All right. Ms. McCarroll backed her vehicle into a marked patrol car. She told Deputy Talton. Good, sorry. Actually, that's right over. All right. All right, go ahead. Keep going.
I've got it muted up here.
You see Ms. McCarroll back into a marked patrol car. You hear her say that she saw the blue lights. You hear her say she had 2 Jaeger bombs, and you hear somebody else, the bartender, say that they were 2 doubles. Over just a couple hours, good bit of alcohol. Other factors you hear from the state trooper I'll talk to you about here in just a little bit. I'm going to pass this over to Mr. Poole for his closing arguments, and I'll talk to you all again in just a few minutes.
thank you all for your patience today and yesterday in particular as well. This is our opportunity to talk about the evidence that's been presented and the law that applies to the evidence. The judge will give you the law, and the state's correct. Our closings aren't evidence. Our closings are arguments, a closing argument. And I want to go through some of the evidence as I recall it, and you will recall it differently. You will have somewhat of a slightly different perspective, and we rely on you all to be fair and impartial, which is why you were selected, based on your answers and your assertion and your oath to do just that. But I want to go through the evidence sort of in order of how I think it was presented, and then talk a little bit about the law as I think it applies. But Deputy Daly was the first officer to testify, and he, as you recall, started initially saying, yeah, talking about an October incident which never occurred, and then suddenly switched to March. And, you know, accidents happen. You've seen me be nitpicky and obnoxious about details that you all probably are like, Blake, this doesn't matter, please stop. The point is not to drive you nuts. Sometimes I get lost in my own train of thought, but the point is to show change in story, change between themselves, change even within a singular officer's testimony from yesterday to today, or what happened that day to what you've heard today. But the point of that was to show, like, okay, maybe there's some level of just going with the flow and answering incorrectly and not really even realizing it. You know, possibly even worse than that, but we don't have to explore that. You get the point. You know, he's called out for a dispute in keys, and that's consistent throughout. And even as you hear in the radio traffic and Bryant's testimony was, I mean, he calls about an accident, and you hear them say to Dawn after she's out there 15, 20 minutes with the deputies, and she's like, why am I being held? Why can't I go use the bathroom? Well, you're being held because of an accident. Now you're being held because of a DUI issue, not the bartender called because she was worried about Dawn, none of that stuff. Everyone's called out because of a dispute and some keys, not because Dawn's DUI or the bartender's concerned about her driving home, unlike the man she was with. And the body cam from Deputy Daly clearly shows Ms. Cherry, and she says, I mean, she does say she served a couple of Jaeger bombs, and she does say she served doubles, I believe. And she said when she testified, she doesn't really recall a couple of years ago, but she thinks they were consumed, and that's kind of really the extent of it. It doesn't seem like she really knows, and certainly isn't ever asked, like, okay, did you see her drink them? Were they gone at that point? I mean, consumed to me, having waited tables could be, well, it wasn't there when I went to go clean up, so I assume it was consumed. Well, that could also be consistent with everything Dawn said the whole way through, which is I took a drink with me and ended up throwing it out. Of course, no one ever looks to corroborate.
You can't just take your alcohol with you. You can't just get a to-go cup of a Jaeger bomb and take it out the door and throw it out on the way out the door. Come on, sir. We're not stupid. She drank them.
Operate that. I mean, in walking distance from the Jeep to this restaurant, no one even does so much as to check. And she says, the one person in this entire trial who doesn't have a dog in the fight is Miss Cherry. Think about that. I'm biased, they're biased, the police are biased, Dawn's biased, right? You all are not. But the one piece of evidence you heard from the person that's not biased is the video from Miss Cherry when she says, she was fine when she was talking to me. Those are her words. She was fine when she was talking to me. I mean, she's the only person in this whole thing, doesn't care how this goes. And she didn't get up there and say, oh yeah, I was really worried about her. No.
They don't give you to-go cups for alcohol. You can get it for soda or water. So if you're ever at a restaurant and you want to take your alcohol with you, you have to ask for a cup for your water. But they won't. Here, they won't let you take alcohol out the door. You're just not allowed.
She said, no, my concern was the guy. I thought she was going to let him drive home. She was concerned about the keys and called police because of the keys. But, I mean, they called her to the stand to come tell you that she had a couple of drinks, she served a couple of drinks, and I guess she was concerned about the guy and the keys. But her testimony is, and was today even, she wasn't concerned about Dawn and wasn't concerned about Dawn driving. Ms. Cherry took the stand, talked about him and just being worried about him. And then Phillips, Lieutenant Phillips, took the stand. And he testified, if you recall, and maybe I mishear stuff, maybe, and I make mistakes all the time. But my recollection is one of the first things he said is he heard Bryant call over the radio loud while trying to call in the tag, and then says, hey, well, you can clearly see he's not on the radio at that point in time in the video. Again, a little nuance, a little small piece of the puzzle that in the scheme of things doesn't matter a ton. But the point is, with each of these officers, there's variation that's inexplicable, that's not explained to you. And the best explanation is sort of a willingness to move and shake between the facts to try to get a conviction.
I've run out of the bar many times to go get my alcohol back into the building. I just have.
He says he was called there because Bryant was involved in a motor vehicle accident. Doesn't say he was called out there because of DUI or suspicion of DUI or anything like that. Testified, as we all know, it's common sense. Obviously, officers can get in trouble if they cause wrecks, right? It's not novel. But the point was that Bryant had already had one, and if you get a second, you have a suspended ability to drive for a while. And that's why I solicited that through him. Initially said, if you recall, an important part about credibility that you all get to decide, if you recall, the lieutenant testified when I was asking him about his report. I went through and said, well, you put in there the lights are on, and you did that because Bryant told you that, right? Well, no, I did it because of Bryant and because Ms. McCarroll said that. You said that 2 or 3 or 4 times probably. And you recall there was a discussion about it being hearsay. I tried to tender it and couldn't because of hearsay, that being Ms. McCarroll's statement. But you probably also recall he then backtracked off of that, and after he read the entire narrative and said that entire narrative was written by Mr. Bryant or Deputy Bryant. So it was something that Bryant wrote and submitted to him. And to me, that's telling because obviously that's inconsistent with the video. Obviously that's inconsistent with what happened. And it was submitted later on that night. I mean, it ain't like he forgot his lights were off. And then he wrote that narrative saying the lights were on. Again, we're not here to find out if lights were on or off or who hit who. That's not what we're here for. That's not the point. The point is people's willingness to say whatever they think is necessary to win a case. Also, what's noteworthy is that report makes zero mention whatsoever of Ms. McCarroll being under the influence, if you recall that as well. And so then Bryant testifies. He testifies, and you hear through his audio and video that Dawn said she had 2 drinks and threw 1 out. He didn't check the car. Nobody checked the car. Every time I ask about an inventory, they're blaming the trooper. No, the trooper had to do that. No, he made the arrest. It's his job. Well, you clearly see at the end, well, actually, you guys were supposed to do it. Again, not trying to make a mountain out of a molehill, but all these little things matter, right? What if they had looked in the trash can and found that drink that Dawn threw away? What if they had looked in the car and found a bottle of Jack Daniels that's half drank? I mean, wouldn't that matter? Like, that's why we gather evidence. That's why we gather this information. That's the entire point of an investigation, not to just show up and ask a few questions and jaw jack around and tell each other jokes and ha ha ha, licensia, give me your licensia, or whatever kind of offensive crap that was. It's not an investigation. It ought to piss y'all off. It's ridiculous. And we show up and we say, well, you're under arrest. I mean, she's sober as a bat, walking fine. There's not any reference in any of these reports or anybody ever saying, well, she can't walk straight. She's holding herself up. She grabs onto the hood of the car. She got slurred speech. I mean, none of it. Like, she's fine in the video. Quirky, unique. And you heard reference to her, you know, she made a joke about her counselor and stuff like that. I mean, like, sure, okay, a little behavior that is different than mine. Whatever, but not an indication of impairment at all. And you heard from Brian himself that he already had 1 at-fault wreck, and he's the one that testified and acknowledged if you get a second, that can lead to a suspension. His testimony was, when asked about manifestations of being under the influence, that she admitted to having a drink and had the smell of alcohol on her breath. And then the trooper testified. And he testified about many times over and over, what are these manifestations that you saw? And y'all recall better than I do, but what I recall is that she got in this wreck and she admitted to having 2 drinks, her demeanor, and then some other stuff within the demeanor, like not knowing, you know, why she was arrested, asking the same question repeatedly, things like that, crying, and then being argumentative and cursing. I mean, all that to me is demeanor. Needing to use the restroom. I mean, you can see when they play these videos, you can see how long each one of them is. They don't play the whole thing all the way through, but you can see each one of them is over an hour long. And we wait for at least 20 something minutes until the trooper gets there, and his is an hour and something long. It's like, I mean, she told the truth and said I had a couple of drinks and had some water too, and we're out there for an hour. But because she has to use the bathroom, that's why I made an arrest. Because she smoked a cigarette, that's a clear indicator of impairment. And as far as standard operating procedures and things like that, I mean, obviously no inventory was done, things of that nature, but what else is telling about, I mean, the trooper in particular, is he acknowledged, his testimony yesterday was bloodshot eyes, bloodshot eyes. That's what's written in the report, bloodshot eyes, which is a buzzword in every little DUI case. Well, so I go take a screenshot from the video, and I grab the best one I can grab, and print it out and, it's a bad angle and this and that. And so, well, my job is not to even print that thing out and bring it and show white eyes. Their job is to prove red eyes. And now we show up today in front of the jury after I present that, and suddenly they're just slightly bloodshot. No slurred speech, no unsteadiness on her feet. And when I ask him, well, based on all these years of experience and all your training, what else have you been trained to look for in a DUI? He pauses for 30 seconds. And then all he says, the same stuff he's already said 4 times, is, well, she hit the car and all the same, she cursed and she smoked a cigarette and whatever else. And he acknowledged he wasn't even aware until trial today that Dawn had said she'd thrown a second drink away. I'm like, okay, well, would that have possibly changed any kind of decision-making process? Well, I don't know. Okay, well, officers convey only the worst information. That's not unbiased. That's not fair and balanced. It's like, she said she had 2 doubles and that's within the last 2 hours and whatever. It's like, no. She said she had a couple of Jaeger bombs and that would still be accurate if it's a double. And she said she threw her second drink away. And she didn't say anything about 2 hours. And obviously it should impact decision-making, right? But the officer, with all due respect, can't even honestly tell you all, yeah, that may have impacted things. Yes, it may have impacted things. It's like, why is it so difficult to answer the most basic of questions? And then, she told him multiple times she wasn't under the influence. And I bring out this point where, like, okay, you want to hold her responsible for, because she said she saw blue lights, which we all know weren't on. She's mistaken about seeing blue lights, like it's undisputed at this point. But no, I did it because, she was believable and she was right. And she said she saw them, therefore they must have been on. It's not that she could have been mistaken about that. So I believe her on that because it helps me as the officer in this case, but I'm not going to believe her when she says I'm sober, I can drive, I threw away a drink or all that. I'm going to pick and choose what parts I do want to believe. And, the biggest issue to me is a couple things. One, obviously, you see in the video, she's arrested prior to being asked for blood, and she refuses that, saying she doesn't want to do a blood test because she's afraid of needles. That's perfectly lawful and shouldn't be held against her. That's totally legal. Nothing wrong with that at all. And keep in mind, that comes after she's already been arrested. The decision's already been made at that point. It's not like there's hope for going back and fixing the situation. He placed her under arrest prior to that. Like, he doesn't need a blood test. Like, it's clear as day to him because she smoked that cigarette and needed to pee.
I'll just caption the case so I can keep my stuff in order. This is the state versus Don McCarroll. Don't worry about that case number, y'all.
You didn't need to hear the rest of it. We got the good part. I only got a small sliver of this guy's too. A way smaller sliver because this is the second time up.
I'll see it a few other times in some other documents, I'm sure. Don McCarroll, the defendant, is charged with 1 single count. It's driving under the influence of alcohol, less safe. There's a handful of elements you got to pay attention to on this charge. Was she driving a vehicle? Was she under the influence of alcohol? And was she, in fact, a less safe driver?
Now we get the verdict.
So Ansley told me that Ms. Fuller was in here. Okay. Okay.
I got it.
They're waiting
It
on
might be a second
someone,
if
so
you want to have a seat.
I'm going to just bump it
Or you
ahead.
might not want to have a seat. You might want to relax, but we got to get Ms. McCarroll out.
1 minute. They're waiting on the court reporter, I believe. There she is.
All right. So I just need to make sure I've got my court report. Everybody else is assembled. I think I might have them muted. I'll see Sharon.
All right, listen. I don't want to answer that question because we're about to find out something else about her. There's 3 minutes and 35 seconds left in this video, and we're about to find something else out about her. So, Granny, I'm not going to answer that question yet. The answer is yes. She's been in jail this whole time.
I think I can hear her. Hang on. What's going on that I can't hear you? Sharon, try and say something again.
Can you hear me now?
I can, but I don't hear you through. It's okay.
I can hear y'all fine, so that's all that matters.
All right. All right. So I've been informed by the bailiff that the jury has reached a verdict. Is everyone ready to receive the verdict? All right. Bring the jury in. All right, everybody please be seated. Except for you, Mr. Shields, I'm going to ask that you stand up with me for just a second. Mr. Shields, I understand that you're the jury foreperson, is that correct?
Yes, ma'am.
Okay, and have y'all reached a verdict?
Yes, ma'am.
Okay, was it unanimous?
Yes, ma'am.
And has the verdict been filled in, signed, and dated by you as foreperson?
Yes, ma'am.
All right, you may have a seat and hand the verdict to my bailiff, and he'll hand it to me so that I can ensure that it's correct in form. And then as soon as I do that, I'm going to give it to my clerk, Ms. Fuller, to publish. All right, you may publish the verdict, Ms. Fuller, if you can reach it.
State of Georgia versus Don Ellen Furman McCarroll, case number 2024 SR 003427, KMR, jury trial verdict. Count 1, driving under the influence, less safe, alcohol, not guilty. The second day of April 2026, signed by jury foreperson Frederick Shields.
All right. Anything else for the jury from the state?
No.
Anything else, Mr. Poole, for the jury?
No.
No, Your Honor.
All right.
He wanted
Members
a
of the jury,
mistrial.
your service this week is now concluded. Sometimes it may be, up until this point, I've said you can't talk about the case with anybody except each other during deliberations.
Hold on, there's
You
one
are
more
now
thing.
no longer under such instruction. You can talk about this case with anybody you want to, or if you never want to talk about it ever again, you don't have to. It's totally up to you. Sometimes the lawyers find it helpful to know what mattered to you in your deliberations, and they may catch you in the hallway and ask to speak to you. That's totally up to you if you want to do that.
Cash
You
them
certainly don't have
outside.
to. I just want to extend my thanks to you. I know that jury service is a burden. I know that you have other things that you needed to be doing. However, we can't get the work done that we need to do here in court without you. So I very much appreciate your service and your attentiveness this week. Checks in the mail, Ms. Fuller?
They sure are.
Checks are in the mail, and you're excused for the term. Thank you very much. You may be excused. All right, everybody can have a seat. Ms. McCarroll, obviously, you have no further obligation in this case, and you're discharged from this charge. Is there anything else? I mean, obviously, she's being held by another jurisdiction, so there's nothing else really for me to address, is there?
Not that I can think of, Judge. I mean, I
Okay.
don't think so.
And she doesn't have any other charges pending here in Hall County, correct? Okay.
Not
All
in Hall
right.
County.
Okay. Well then, anything else for me? All
Nothing
right,
else,
well,
Your
all
Honor.
right, we'll stand in recess.
Thank you, Judge.
She's still going to jail.
No need to get
They're
yours
still
off
going to
straight
take her
from
back to
March.
jail. I don't know why. I don't know what she did in that in the other jurisdiction. But not guilty. Not guilty of driving less safe because of alcohol. She did hit a cop car, but she's still a safe driver. But I don't know if you guys saw it or not. I can't remember if I left it in. The officer that she hit had been in a couple accidents prior and is not allowed to have any more accidents. He's not allowed. And he got in an accident this day. So it was a big deal. When she said he hit me, that was a big deal. That officer would have been toast had that been true. But it was not true. So, but she's not guilty probably because their stories didn't line up to the truth. It wasn't off a lot, but it was off enough. She should have been toast because she didn't take any blood test or breath test or anything like that, and she hit a cop car, and she said she was drinking. She should have been toast, but her lawyer did a good job, and she's still in jail. Yeah. Love you too. I'll see you all again tomorrow. Have a good day. Bye, guys. Thank you so much.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we my pain. 'Cause this creator takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide. Oh, Kathy's the creator, she's leading the way. At court vibes, we laugh and we stay. Her style is classy, she's always top shelf. Don't take my word, come and see for yourself. Her cases are new with a twist or two. I really like them, I believe you will too. A little lifeline passed along in rhyme. Why don't you join us? It's a guaranteed good time.